Please, item number 2.
When we took up this matter on 6/11/2023, you made a submission that against the judgment and order dated so and so passed in WPC number which was confirmed in REIT appeal number so and so disposed of on 6/9/2022. State of Orissa has approached the Honorable Supreme Court and the matter may be taken up after 4 weeks to obtain instruction about the status of the SL. No, pending is one. There must have been a registration or not.
Diary number is there. Where is that?
Diary number is there. Diary number
Give something otherwise. You see, this matter, the repetition, they got the relief in the year 2010, 2014. A case was filed in 2010, got the relief in 2014. Writ appeal dismissed. Now almost 10 years is going to be left. And the judgment of the Honorable this court division bench judgment in that writ appeal in 6/9/2022. So 1 year and some months have passed. So you had got ample opportunity to get some order, if any. But merely filing the SLP, that would not do. Who knows that what would be the fate of? So that is why you have to implement. If you do not bring any order, staying the operation of the order of the past in the writ appeal, then you are bound to follow the otherwise it will be.
This is the weekly order.
Yeah.
So let it taken tomorrow. I will get out. What is the status?
All right, there is no. And in that light also, there are a number of decisions on that. Somebody suppose in a trial court makes a submission that I have filed a challenging a order in the revision petition. So that will not be a ground to stop the criminal trial. Unless you bring the order, then that is a different matter.
So filing of your SLP ipso facto will not be taken as the stay of.
Right. And reasonable time is of course to be given. Know that what is the duty. But 1.5 years is sufficient.
Number 7. And some more time.
The last order was on 30/10/2023. When he submitted the last status report, that was dated 3/10/2023, and in that status report, he sought for 1 month further time to trace out the victim girl as well as to apprehend the accused. So, what you have done, that IIC is not present today.
Because they are personal appearance.
All right. No, but what he has done.
Last time also the section of the council also submitted that we give some relevant information.
So if he gets something, then it will be supplied. Otherwise, what can he do? When your police agency is not getting something, why? How can you expect? Yadi kaku phone fan kala se jio.
The status report doesn't reveal any tangible state.
By the way, what is the date of birth of the victim? As on the date of occurrence.
Ten 7/2006.
10/7/2006 means
On the date of filing, it was 16 years 7 months.
ಈಗ 17 ವರ್ಷ ಇಲ್ಲ 17 ವರ್ಷ 5 ಮಾಸ ಪಾಠಾಪಾಠಿ ಇದ್ದಾನೆ. Any case has been filed in the before this court, CRLMC or APL, APL, ଆପଣଙ୍କର instruction ଯାଇଥିବ ନା ମାନେ concerned IIC କୁ to send the case diary.
I will also check the CRM.
BLAPL किंबा CRLMC washing ପାଇଁ ହଉ କିମ୍ବା anticipatory bail ପାଇଁ. ଲେଖିଦିଅନ୍ତୁ non-appeals for the petitioner. The learned counsel for the state has produced the status report regarding progress of investigation in Bodamba case number 347 of 2022, submitted by the IAC of Bodamba police station, wherein it is indicated what are the steps taken by the IO for tracing out the victim and for apprehension of the accused. The status report, in the status report, it is further prayed that 1 month more time be granted for such purpose. The status report is taken on record. Learned counsel for the state submitted that will verify whether the accused has filed any anticipatory bail application or any application challenging the criminal proceeding instituted against him before this court. Put up this matter. Second week of January, second week of January, free copy of the order be handed over to the learned counsel for the state.
IAC to be present.
Acha, okay. Let the IAC of Bodamba police station be present on the next date with the up-to-date instruction.
Number 24.
Yeah, in this case, W1 and W5. Right. W1 statement is that he had gone to sister's house and he was returning the sister's house, he had returned from half kilometer. When he was returning to his own house, in the village darkness had appeared. He could be able to see that the Govinda the assailant, leaving one Uradi as and followed by one row of leg on the disease. So this is the Lokana, and I saw that Dharani and Lokana, Dharani is disease and another is the Lokana. They both were talking together. At that point of time, that is 7:30, at that point of time, I heard the assailant gave the blow. Then we raised the Halla, hearing the Halla, and Pradeep and Raju, they rushed to the spot, and thereafter he went to his own house, narrated the occurrence in front of his own house, he went inside the house, disclosed before his father, and father is PW5. They both came to the spot. Thereafter, they went to the house of the deceased father, PW6, with the informant, father informant, disclosed before him and his another son, some who had not been examined. And thereafter, they came here and they lost the PW6 lost the PW, my submission regarding PW1 that 10 numbers of houses are there in and around this spot. Nobody has come forward hearing the hala. And if not examined that out of fear, they remain inside by closing the door. Only Pradeep and Raju, they came. Hearing the hala, they came. Not that they are passerby. Hearing the hala, they came only. And Raju's house is at a distance of 300 to 400 meters. And Pradeep's house is half a kilometer distance. They came to the spot hearing the hala. But the other 10 inmates, houses are 10 in number. The spot where 14 would indicate. 10 in number almost. The inmates, they are not come after hearing the hala. Even from his own house, his father, he has not come forward to the spot. Yes. This is with regard to the submission of PW1 before your worship. And this is not free from suspicion. His presence at the spot matter is not free from suspicion. Then you also may see the other eyewitnesses, PW9, and in the morning, PW9, then deceased and the apparent, both the three had gone to the house of this PW5 for construction work. They returned in the evening, and in the evening after half an hour, they went to his house for payment. There was no change money. They three returned, appellant and also deceased, and also the other eyewitnesses PW9. The three returned to Talapada. Again, the three again after half an hour, they came to the house of Kalia Kisan for payment. On the way, my lord, the one Saraswati Naik PW7. Here, my lord, PW5 has been declared hostile. PW2 has been declared hostile. With the sky of the affair, and PW7 Saraswati has been declared hostile. Saraswati, my lord, this is disbehaved, wanted a bhang from Saraswati, and Saraswati denied, and it is allegation that they outraged modesty, and Govinda the assailant took Saraswati to his own house and disclosed before Abhi. Abhi is another co-accused, and Abhi gave two slaps to Saraswati, and prosecution case is that Govinda and Abhi both came and gave Govinda gave this proof. And the PW9, the other eyewitnesses, Lakshmana Kumara, he named these two persons, injured, appellant Govinda and deceased at the spot where there was quarrel ensued, and he went to the house of Kalia Kisan alone for payment. When he returned, and at about 7:30, it's in both the time is 7:30. In view of the submission of PW1 and in view of the submission of PW9. When you are there talking with the deceased, appellant Govinda came along with the Abhi. Govinda gave the one blow at the head, followed by the other blow at the neck. And PW9 played away, went to his house and disclosed before his father regarding the incident. So my submission before your lordship, on the very face of it, regarding PW9, for your lordship's kind appreciation, I will be submitting that PW1 says that Pradeep and Raju, those two have not been examined, and Raju came at a distance of 300 and 400 meters. Pradeep came at a distance of half kilometer, but in and around 10 houses, and no inmates have come. Even his own father, in front of his father, the occurrence took place, and he has not come. And PW1 says that Lakshmana Kumara was talking. PW1 says that Lakshmana Kumara was talking at about 7:30 with the deceased. And your lordship may kindly see, PW1 has seen Lakshmana Kumar by remaining at a distance of 20 feet, and he witnessed the assault. And Lakshmana Kumara is PW9. When one eyewitness is able to see, your lordship, other than rightly said that who is going, who is coming cannot be seen. But two eyewitnesses, occurrence time is 7:30. In view of the mouth of both the two eyewitnesses. One by remaining at a distance of 20 feet.
No, it is 10 to 15 feet.
10 to 15 feet, yes. 10 to 15 feet. Could be able to see other eyewitnesses. But the other eyewitnesses statement is that he has not seen anybody. And they were talking behind below the electric pole. And the PW9 was standing at a distance of 3 feet. And PW1 is there at a distance of 10 to 15 feet. PW1 could be able to see PW9, the other eyewitnesses. The other eyewitness excludes the presence of PW1, and he has said, gone to the extent of saying that there was nobody, and he went away. This is regarding that they have developed two different stories, suffered from major contradiction because time is 7:30. At 7:30, two eyewitnesses cited by the prosecution. One says that he is able to see other eyewitnesses talking with the deceased, but the other eyewitness PW9 is not saying excluding the presence of PW1. So both the two eyewitnesses relating a particular point of time, that is 7:30, their statement with regard to presence of vice versa is, your lordship may kindly consider what is the position, whether they were there in the spot. If one is not there, you have the evidence of other, my lord, your lordship may kindly consider to disbelieve the same. That is my suggestion.
No, one was not there. You are relying only that line of from that PW9 evidence. PW9 says that I have not seen any other person in and around the spot. So that from that line, you want me to say that that excludes the presence of PW1 at the spot.
And before that also he has said he has not seen anybody. Has not seen anybody.
Dita line I had not noticed anybody of our village on the way, and I have also not seen any other person in and around at the spot.
Related to that point of time, 7:30.
Okay, so suppose he makes a submission. If you say that I have not seen anybody, whether that excludes the presence of that nobody would have been there. It's a evening time, let us say 7 o'clock. What would be the position of a person, and whether this man was focusing on the assault part or any else. He has just given it that I had not seen it. So you may say that he had not seen. That would not exclude the presence of others. It's a village. How do you say it's a village? It's not a place where there would be nobody, or the presence at that point of time would be very unnatural. In the village, when the houses are there, and on the village road, this occurrence took place in front of the house of PW1. Okay, so presence of other villagers are very natural. It's not a, let us say, it's a late in the night.
Says that no other villagers were
No, it's all right. But question is that who would be in what position? Who would be in what position? That nobody can say. One may stand and see, and they may go away inside the house after seeing the occurrence. So what would be his reaction, and whether a person would, when this type of occurrence is taking place, he would first focus on that assault itself. Ordinarily, it is not expected that he would know each and every person who are there. Might have been given a glance, he may say so. But ipso facto from that particular line, whether the presence of PW1, who is an eyewitness and whose evidence has otherwise not been disbelieved, or otherwise has not been second in the cross-examination, can only on one line or two sentence of one another eyewitness, the presence should be disbelieved. That is what
PW1 says that I was coming, darkness had appeared, and I saw that other eyewitnesses and witnesses they were talking. It fits into that point of time, that is 7:30. Everybody, both the eyewitnesses say 7:30. And when I saw the assault part, I raised Holla, Pratima and Randu.
No, that we have noted. That you say that PW1 has stated that 2 persons came to the spot.
And immediately assault took place.
Right. Those 2 persons have not been examined. Right.
So those who came.
हाँ ठीक अच्छी आपण जो प्रदीप आ गोटे कौन ना
मुंडा
Raju and
हाँ ठीक अच्छी सेमाने PW1 कहूची the line टा होची या I raised Holla. Hearing the Holla, one Raju Munda and Pradeep Naik appeared at the spot. Hala?
again.
Then the accused Govinda along with Abhi Naik fled away from the spot. You know what your submission is that Raju Munda and Pradeep Naik, who appeared at the scene of occurrence immediately after the assault took place as per the
Really,
version of
really.
PW, they should have been examined to corroborate the version of. We put a question to you yesterday that how many persons the prosecution is required to examine in a case to establish its case. Is it a number that would count, or it is the quality of evidence of the
Yes, my lord, in fact, this was saying when I raised the point that when PW9 went and disclosed before his father's another son, that was not examined. Relating to that, my lords, in fact, I am subject to correction. Said that his question of number of witnesses, evidence need not be counted, it is to do where that was. But here, my lord, these 2 persons are material witnesses, they have been withheld. Raju and Pradeep, they are the only witnesses say that PW1 is there. And hearing the Holla, they came. And
how this man, yes, let us say that PW1 would have been an interested person. He would have been inimically disposed of towards the accused. And when independent persons are available to be shown as an eyewitness to the occurrence, the prosecution should have been fair enough, should not have withheld. But what is your grievance against this man, PW1? How you say that he is interested witness or he is inimically disposed of towards the accused, so that merely because those 2 witnesses have not been examined, those Raju and Pradeep, we will also disbelieve the evidence of PW1.
PW1, to him, my suggestion was given that it is not a fact. The answer is that
Suggestion you can give the
suggestion that because they were the laborers in his house, there was some payment outstanding regarding that dispute is there. That was
suggestion would
that was suggested. That, to that extent only. Otherwise, nothing is possible. That was the dispute my lord suggested. And your lordship may kindly see.
you see where if you are taking a plea against PW1 like this, when PW1's version was put to you in the accused statement, is it not expected you to take that, sir? Se lokada micho kouchi ei karan pai.
गोटे लास्ट क्वेश्चन सर यू लॉर्डशिप नो द स्टेट डिफेंस
ना स्टेट डिफेंस
सब तो नहीं
सबकुन माफ होई
I will
जाई
take सब
मैं we have to go by evidence. State
Yes, yes,
defense
definitely,
counsel. It is not that he has not been cross-examined or 1 or 2 lines have been. You see the it runs to 2 pages, complete 2 pages, and questions have been asked. It is not that the state defense counsel କାରଣ ବହୁତ କେସ୍ ଅଛି ଯୋଉଥିରେ ରିମାଣ୍ଡ ହେଇଛି ମ୍ୟାଟର କାରଣ ଏମିତି ଫର୍ମାଲି ଜଷ୍ଟ ଖାଲି ଗୋଟେ ସଜେସନ ଦେଇକିନି 302 ରେ ତାକୁ ଡେଥ ସେଣ୍ଟେନ୍ସ କରିଦେଇଛନ୍ତି ରିମାଣ୍ଡ ହେଇଯାଇଛି ବଟ୍ ଇଟ୍ ଇଜ ନଟ୍ ଏ କେସ୍ ଅଫ୍ ଦିସ୍ ନେଚର ଆପଣଙ୍କର କ୍ରସ୍ ଏକ୍ସାମିନେସନ ରନ୍ସ ଟୁ 5 paragraphs and 2 pages are counted in the paper book. So you cannot say that the defense counsel was not prepared at all, not made any endeavor. He has not only put the suggestion, he has tried to extract something. But question is that in spite of all his attempt, whether the defense has succeeded in nullifying the evidence of these 2 witnesses, star witnesses, eyewitnesses, whose evidence is getting corroboration from the medical evidence.
The suggestion is that it is not a fact that at the time of my arrival, many of our villagers were assembled on the road.
You see, defense suggestion is no evidence.
No.
Defense suggestion, you can give the suggestion. You can give number of suggestion. You may say that 1 line that it is false. Okay, but question is that if you are taking a particular plea, then you are to adduce some kind of evidence. Either defense evidence, or bring it through the mouth of any of the prosecution witnesses to corroborate your defense plea or your suggestion. If nothing has been done, merely suggestion and which has been denied, and that particular stand has not been taken in the accused statement, how can we just rely on those suggestions that MP dharo bada ba jaha bhi hoga?
One line that I noticed Dharani deceased and one Lakshmana is Pitable 9 were talking with each other, and I also noticed Govinda giving the proof that at a particular point of time they are related to 7:30. That Pitable 1 saw that two persons are talking, one is deceased, other
And about that identification which you are saying 7 o'clock. 7 o'clock, they are co-villagers, PW1 and PW9. They are all co-villagers of the not only the deceased but also of the appellant.
PW1 saw PW9 other witnesses talking with the deceased at the same time assault took place. Then your lordship may kindly see PW9's evidence. PW9 excluded that nobody. Three things are supposed to be seen. One is the physical corpus of PW1, whether he is present at the scene of occurrence. Then second is the raging holla, the sound. And then my lord appearance of Pradeep and Raju, there are villagers.
PW1, PW9 the presence kahini ki.
PW1 question is in the company.
No, kodi anunanti. Please come to that line.
Yes, PW1 question. Paragraph 3. Houses of Lakhim Kisan, Lima Kisan, Devanand Kisan, Gokul Kisan, Mitra Kisan situated near my house. Houses of Bihar Kisan, Choinu Kisan situated in front of our house, which is interviewed by the village board. On my arrival near our house, I noticed Dharani is deceased and one Lakshmana PW9 were talking with each other, and I also noticed the conjunctive here. And I also noticed accused Govinda and one of the coming here to them. And near to them, and they have given assault. That is okay. So, while written, then other parts is there. So, this PW1, Vijay Kisan, who has seen other eyewitness PW9 by remaining at a distance of 10 to 15 feet. But PW9 also distance is same. PW9 is at a particular place, PW1 is at a particular place, distance is 10 to 15 feet. PW1 has seen PW9 other eyewitness, but other eyewitness has not seen PW9.
PW9 was closer to the deceased at the relevant point of time. So, somebody can see him from the distance, somebody can see him, but the other person may not see him. Apono deceased, ଆପଣଙ୍କ ପାଖରେ ସିଏ ଛିଡ଼ା ହେଇଛି, ମୁଁ ତାକୁ ଦେଖିପାରିବି ଦୂରରୁ, ବଟ୍ ସିଏ ମୁଁ କୋଉ ପୋଜିସନରେ ଛିଡ଼ା ହେଇଛି, ମନେକର ମୁଁ ପଛରେ ଛିଡ଼ା ହେଇଛି, ଇଏ ସାଇଡରେ ଛିଡ଼ା ହେଇଛି, ମୁଁ ତାଙ୍କୁ ଦେଖିପାରୁଛି, ବଟ୍ ସିଏ ହୁଏତ ମତେ ନ ଦେଖି ପାରିଥାନ୍ତା.
That is with regard to seeing the corpus of the physical appearance of PW1. Then question is other item rating holla. Holla has been read, sound has not been heard. Hard is appearance of Raju and Pradeep. Taku bhi se dekhina hai PW9. No, no, kichhi dekhina hai.
But a very relevant aspect that you are living is very correctly PW1 is saying that he has seen Dharani with the deceased.
Yes, yes, yes.
He has seen. So this could have been missed by PW1 if your assertion would have been correct. He has rightly marked, as my lord is saying, the PW9 may not have the, he can't see reasonably, we can't expect that because PW9 is not able to see PW1, his presence could be excluded. This could have been, had PW1 not noticed the presence of PW9 along with the deceased.
With all respect, I am from out of that.
ଆପଣ ବର୍ତ୍ତମାନ position ନେଇଯାନ୍ତୁ, deceased and PW9, ହେଲା? Let us say I am PW1. So I can see evening time, I can see both of you because you are at a very close distance. So you may not, the other person, you may not mark me, I am standing at a distance in the evening hour. So that is possible. Why it is such a thing that we should disbelieve the presence of
one another because somebody is
my lord, my honorable judge, my lord asked me, my lord, that the three things are supposed to be seen by PW9, the other eyewitness. Seeing PW1, physical corpus. Hearing his Allah, and also seeing other two persons. Nothing has been changed. Raju Munda Pradhi Munda को देखना थी, ताकू देखना थी PW1 को, ताका हला सुनना, पीछे सुनना थी because PW1 देखी वाले PW9 की, but my lords rightly said PW9 देखना थी, they suffer from major contradictions.
You see, he has stated that the moment the PW9 Kouchi, the moment this blow was given and he fell down on the ground out of fear, he left the spot.
And he is supposed to see PW1 just before that. It will relate to 7:30. 7:30 ପରେ ଗଲେ 7:30 ରେ ଅପରାଧ ଚାଲିଛି ଇଏ ଆସିଲା ବେଳକୁ 7:30 ସିଏ ବି 7:30 ବେଳକୁ ଦି ଜଣ ଯାକ ଗପୁଛନ୍ତି
ଆରେ ବାବା ଦୂରରୁ ଜଣେ ଆପଣଙ୍କୁ ଦି ଜଣ ପାଖରେ ଯେତେବେଳେ ରହିଛନ୍ତି ଦୂରରୁ ଜଣେ ଲୋକ ମାର୍କ କରିପାରିବ ଆପଣ କେମିତି ମାର୍କ କରିବେ ତାକୁ ଏବଂ ଯଦି ବି ସେ ନ ମାର୍କ କରିଛି ହାଉ କ୍ୟାନ୍ ଦ୍ୟାଟ୍ ବି ଏ ground to disbelieve? Who position who knows that what position he is standing? ଆପଣ ଖାଲି distance ଟା କହୁଛନ୍ତି ଯେ ସେ 15 ଫୁଟ ଦୂରରେ ଛିଡା ହେଇଛି କେମିତି ନ ଦେଖିଲା ଇଏ ତ ତାକୁ ଦେଖିଲା ଆରେ ଆପଣ ଦି ଜଣ ଯେହେତୁ ପାଖରେ ଛିଡା ହେଇଛନ୍ତି ଜଣେ ଦୂରରୁ ଆପଣ ଦି ଜଣଙ୍କୁ ଦେଖିବା ସମ୍ଭବ 15 ଫୁଟ କିନ୍ତୁ ଯିଏ ପାଖରେ ଛିଡା ହେଇଛି ସିଏ ଚାରିପଟ ଦିଗକୁ କଣ ତାର ପଛପଟେ ଗୋଟେ ଆଖି ଅଛି ନା କଣ କୋଉ ପୋଜିସନ ରେ କିଏ ଛିଡା ହେଇଛି କଣ ହେଇଛି ତା ଉପରେ ଡିପେଣ୍ଡ କରୁଛି.
And see the incident. He has seen directly the incident. He has seen directly the incident that has taken place with quick succession.
And PW9 was also seen directly.
No, but he had a different background. Kindly see. He talked, they went away, came with axe, all these things he has seen. But this man has not seen going away, coming with axe. But he is saying that after they came with an axe, stopped. He has come little later than PW9.
No,
you just see.
By 7:30 apparently. And by 7:30
you can't take it that approximation that it is 7:30 and 7. Even if 10 minutes then this side that side
corridor रे छिड़ा हेबे हैना corridor छिड़ा हिनी गपिबे हैना गपिबे से कोसियार वाला कहबो कहबो मु देखथिली दास को से सेठी छिड़ा हेतले आपण कहबे नाइ मु तो ताकू देखिनी ताले से ओसियार वाला रो प्रेजेंस सेठी डिसबिलीव हे जोती की अच्छा कथा
खाली मु सेटा ताली गले न देखिले भी हल्ला सुनना टिके एदी जम सेटा के corridor object kind of
already you skip that माने छाड़ दियो आपण तो सबमिशन करले we noted it. Any other points you want?
Yes, may I just place a PW9 TSL cross place?
Play.
Yes,
you are free to play.
Cross-examination. I was examined by the police on 6th night at about 11 to 12. I cannot say the month of the occurrence, so also the year. Dharani asked for a coiling to Jama near the house of Galia Kishan and Gopur Kishan. Houses of Monu Kishan, Mitra Kishan, and Gaya Kishan are situated near the house of Galia Kishan and Gopur Kishan. By the time Dharani asked for Hangar to Jama, none except Govinda and myself were present there. It was then 7 p.m. House of Govinda situates in front of my house. Galia Kishan did not come out from his house with me. I was talking with the Dharani, standing in front of the house of Galia at about 7.
Govinda is
Aselan here.
The appellant, yes.
At 7:30. 7, then 7:30. Save and except myself and Dharani, none was present there at the time. It is not a fact that other villagers of our village have noticed us talking there. It is not a fact that Govinda and Jama did not return again to this spot. I cannot say the reason for which a war ensued between Govinda and Dharani before the occurrence. But I heard that Dharani and Govinda were engaged themselves in a war, and thereafter Govinda took his own Jama to their house. Next paragraph. I have not seen any other person when Govinda and Abhi came towards us holding the axe. At that time of assault on the I was standing at a distance of 3 feet from them.
That means at this spot
Seeing the assault out of fear, I ran towards my house, and after my arrival in the house, I narrated the incident to my father in our house. By returning towards my house, I had not noticed anybody of our village on the way. I have also not seen any other person in and around this spot. It is not a fact that I am deposing falsehood, and Udia is commonly available. And Govinda, these are the suggestions given. And also the evidence of PW5 with the Kalia Kishan, father of the PW1, the eyewitness, who was inside the house. The cross-section part, page 47, you will see mechanics. Yes. I have not seen the assault on Dharani. Only Lakshmana Kumar came to my house for payment of his wages while I was in my house. I have not seen Govinda Govinda Dharani at that time. At about 7 p.m., I noticed the dead body of Dharani lying on the road in front of my house. I had been to the shop of the Magupanda, which is situated at a distance of 50 to 60 meters away from London. When I noticed the dead body of the deceased, Lakshmana and Vijay were present there. Lakshmana, my lord, had left PW9, but PW5 says that Lakshmana was there. Lakshmana
He himself was not there.
He PW5 hotel, PW2 hotel 7.
ये जो लाइन टा कहूची PW5 is the father of PW PW5
PW1 ର father
PW1 ର father से कौन कहूची I came to know from my son Vijay. Vijay माने PW1.
Yes.
তাহলে এইটা corroborate করুনি PW1 ର evidence
ସେ ଶୁଣିକି ଯେତେବେଳେ ଆସିଲେ ଲୋକଙ୍କର PW9 ଯୋଉଟା
ଜଣେ ତ ପଳେଇଲା ସାଙ୍ଗେ ସାଙ୍ଗେ PW9 ପଳେଇଲା କିଏ
ଏଇ PW5
ମାନେ
ସେ known to ଲକ୍ଷଣ କାରଣ ଲକ୍ଷଣ ତାଙ୍କ ଲେବଲ ଲକ୍ଷଣ ବି known to PW1 ଆଜ୍ଞା PW1 ଯେ ଇଏ ଲକ୍ଷଣ ତା ଘରେ କାମ କରୁଥିଲା ଭିଲେଜର ଆଣ୍ଡ କାମ ବି କରେ ସେଉଠୁ ପଇସା ଆଣି ଆମେ ଯାଇଥିଲା ଲକ୍ଷଣ ଆଣ୍ଡ ବିଜୟ are present there.
When I noticed the dead body of the deceased, Lakshmana and Vijay were present there. So Lakshmana ki
the person but he said that he immediately left.
ହେଲା Vijay
ହଉଛି PW1 ଯେ ତ ଖବା କଥା ଡାକିକି ଆଣିଲା ବାପା କିନ୍ତୁ ଲକ୍ଷ୍ମଣ ପଳେଇଲେ PW9 କହିଲେ କିନ୍ତୁ ଲକ୍ଷ୍ମଣ ଅଛନ୍ତି ସେଠି ଆଉ ସେମାନେ ସବୁ ଜଣାଥିଲା ସେଠି କାମ କରୁଥିଲେ ତାଙ୍କ ଘରେ ଟଙ୍କା ପାଇଁ ତାଙ୍କରି ଘରକୁ ଯାଇଥିଲେ PW5
ନାଇଁ ନାଇଁ ଆପଣ ଯୋଉ PW9 କୁ ଯୋଉ ପ୍ରଶ୍ନ ପଚାରିଲେ ସେ କହିଲା ଯେ ଗୋଟେ ଲାଇନ ପଡି ରହିଗଲା I fled away from the spot. So ଆପଣ ପଚାରିଛନ୍ତି କି ଆଉ ଡିଫେନ୍ସ ରେ ଆଣିଛନ୍ତି ଯେ ତାପରେ ଆଉ ଆପଣ ସେ ଜାଗାକୁ ଆସିନାହାନ୍ତି
and the whole evidence has to be read in consonance.
ଆଉ ଗୋଟେ ଲାଇନ ଏଠି କହିବି ଯୋଉ ବିଜୟ ଲକ୍ଷ୍ମଣ and Vijay are present there. ଆଜ୍ଞା ତାପରେ thereafter ରାଜୁ and ଗଜେନ୍ଦ୍ର ପଦିନାକି arrived at there. PW1 କହୁଛନ୍ତି ଯେ ମୋ ହଲ୍ଲା ଶୁଣିକିରି ରାଜୁ ଆଉ ପ୍ରଦୀପ ଆସିଲେ ମୋର ଅଥରୁ ସମିଶନ ବିଫୋର ୟୋର ଲର୍ଡସିପ ଯେ ଅଦର ଆଇଟନେସେସ୍ କହୁନା ଏଠି PW5 ଯାହାକ ଦାଣ୍ଡ ଆଗରେ ହେଲା ସେ ସବୁ ଜଣାଶୁଣା ସିଏ କହୁଛନ୍ତି ଯେ ପ୍ରଦୀପ ରାଜୁ ପରେ ଆସିଲେ after his arrival. And PW1 के ତାଙ୍କ ପୁଅ କହୁଛନ୍ତି ଯେ ମୋ ହଲ୍ଲା ଶୁଣି ସାଙ୍ଗେ ସାଙ୍ଗେ ସିଏ ଆସିଲେ ଜଣେ 300-400 ମିଟର ଦୂର ଚାଲି ଆସିଲେ ଜଣେ ହାଫ କିଲୋମିଟର ଦୂର ପଳେଇ ଆସିଲେ ଶୁଣିକି ହଲ୍ଲା ଶୁଣିଲେ ସାଙ୍ଗେ ସାଙ୍ଗେ ଆସିଗଲେ ପାଛ ଜଣେ ଅଧ କିଲୋମିଟର ଆସିଲା ଜଣେ 400 ମିଟର ଆସିଲା କିନ୍ତୁ ଯୋଉ ଅତି ସାମ୍ନାରେ ଯୋଉମାନଙ୍କ ଘର ଇଭିନ ହିଜ ଫାଦର PW5 ସିଏ ବି ବାହାରିକି ଆସିଛନ୍ତି ଦାଣ୍ଡ ସେ ତାଙ୍କ ପୁଅଠୁ ଶୁଣିକି ଆସିଲେ ପୁଅ ହଉଛି ଗୋଟେ ଆଇଟନେସ୍ ଆରଟା ହଉଛି ଆଉ ସେ ଅଦର ଆଇଟନେସ୍ ଟା ତାଙ୍କ ଲେବର ସେ ତାଙ୍କରି ପାଖକୁ ପଇସା ଆଣିବାକୁ ଯାଇଥିଲେ PW5 ପାଖକୁ. It is not a fact that Vijay did not disclose the other things are there. So before your lordship, my prayer is to consider these two eyewitnesses nobody has seen and it suffer from major contradiction. They have said in view of the surrounding circumstances, so for PW1, my lord, Rajimunda, Pratimunda, they are coming also is not believable and they are not also being examined corroborated PW1. And PW1 who saw PW9 vice versa has not seen immediately played out. But his father says that PW9 was very much there. They are not played out. Asking in the cross-examination, your lordship, regarding that, my lord, I will bow down before your lordship. For totality of circumstances, your lordship may kindly see my submission regarding PW1 and 9. They both suffer from two different stories, two things and major contradiction. Relating to 730, their presence not believable and it is excluded to PW9 for minors to consider.
Yes, Mr. Tripathi.
And
No, direct. I'm very sorry, William.
Two
କୁହନ୍ତୁ କିଏ ମନା କରୁଛି?
witnesses have said that the injury was given by sharp side.
Who?
PW 58 page yellow.
Doctor.
PW 9 eyewitnesses say.
Eyewitnesses.
Eyewitnesses.
Sharp side.
Last line, we have 58. Govinda assaulted Dharani by the sharp side of the axe.
କୋଉଟା?
Page 58 PW 9 evidence paragraph 4 last line. Govinda assaulted Dharani by the sharp side of the axe to his head and neck. ଆଉ ଜଣେ witness ବି କହିଛନ୍ତି sharp side. Doctor ବି କହିଲେ it is possible only by sharp side. Two lacerated injury.
ଆଉ ଗୋଟେ କିଏ କହିଛନ୍ତି? ଆଉ ତ ୱିଟନେସ୍ ନାହାନ୍ତି 1 ଆଉ 9 ଆଉ କିଏ କହିବେ?
ଆଉ ଜଣେ witness କହିଛନ୍ତି.
କିଏ କହିବେ କହୁନାହାନ୍ତି? 1 ଆଉ 9 ଯଦି ଆଇ ୱିଟନେସ୍ ରହିଲେ ଆଉ ତ କିଏ ଆଇ ୱିଟନେସ୍ ସେମିତି ଆଉ ସାର୍ପ ସାଇଡ୍ କଥା କିଏ? ହଁ ସେଇପରା ଯଦି କହିବାର ସମ୍ଭାବନା ଅଛି ଏଇ 2 ଜଣ ହିଁ କହିବେ। ହଁ ତେଣୁ ଇଏ କହିଲା ଆପଣ ଦେଖେଇଲେ 1 ନମ୍ବର ସାକ୍ଷୀ ସେ ବିଷୟରେ କହିଛି କି?
Just ଅନ୍ୟ witness କହିଲେ କିଛି ଲାଭ ନାହିଁ. Then the doctor says that it is possible, and 2 witnesses have to give at least one eyewitness says that the sharp side has been used, and
no, he has not said. I also noticed that he gave another blow by means of the said axe on his neck as a result. So nothing comes.
Sharp side, you are right that PW9 has but the doctor, this axe was seized yesterday also. This axe was seized. It was sent to the PM doctor, that is PW8. And again, please come to the paragraph number 4. Please come to paragraph number 4, place it and then make it.
PW8.
PW8, huh? No doubt the 2 injuries are lacerated wound. Please read it. That's paragraph number 4.
Police requisition. I examined product weapon of offense. One axe with a wooden handle wrapped by plain paper. A description of which is made of solid part, made of iron with a wooden handle inserted to the bone. Length of solid part of iron portion is 5 inches. There is a sharp cutting edge. Length is 2.5 inches. Blunt end 1.5 inches. Solid iron part contains some unknown. Then which is looking like it's added. The length of the wooden handle is 57 inches and circumference is 60 inches. It is broken slightly at the lower end. On my examination, I have opened that it is found in my postmortem report and possible by the producer. After examination, I see the weapon, label it and hand over it to the appropriate afterwards. This is my jury report also. This is the act I observed. Then my cross examination. I received the axe which was wrapped by paper but not sealed. I had affixed a paper slip putting my signature over it. I put a paper slip on the iron portion of the axe but my signature does not appear on the paper slip affixed on the iron portion of the axe which I examined. By the time I received the axe, there was no paper slip affixed either on the wooden handle or on the iron portion of the axe. Inside wound can be possible by the sharp side of an axe. Lacerated wound cannot be possible by the sharp side of the axe, but is possible by the blunt side of an axe. The injuries which I found over the dead body of the deceased cannot be possible by one fall against a rocky surface of rock. External injury number 1 can be possible by a single fall against a hard and blunt or rocky surface. It is not a fact that I am not examined the weapon of offense as is not a fact. So my submission before your lordship that regarding the use of this axe, apart from the fact that 2 witnesses have said Even police has said it is commonly available. That is one.
Hmm.
Commonly available.
Hmm.
Second is minor. It was not sealed, no
Hmm.
signature. Third is before minor seal or seal is ultimately regarding 14 police manual 37. How to be the Malkhana, how to be taken out. In that Malkhana register has not sealed. And while sending into chemical exemption, cross state.
କୋଉଥିରେ
ହେଲା କିନ୍ତୁ এটা human blood বা ମୋ blood ସାଙ୍ଗେ ହେଇପାରେ it was deteriorated. You will come to the benefit.
No, you come to the C report. That is
Yes,
actually
yes,
55 ରେ human blood ଅଛି ଆପଣ ନାଇଁ କଣ କହୁଛନ୍ତି ଆକ୍ସଟାରେ ଯୋଉଟା ମାର୍କ ହେଇଛି C wooden handle blood ଅଛି
ମୋ blood will ତ
ଏଟା proof ଟା ନାହିଁ ମାନେ A B ଏଗୁଡାକ ନୁହେଁ କିନ୍ତୁ human blood ଅଛି
human blood ଅଛି but no opinion because deteriorated it is deteriorated.
Let us say it a worst case total weapon
Is not.
siege ହେଇନଥାନ୍ତା ମୁଁ କହୁଛି ତାକୁ ନେଇ ଆକ୍ୟୁଜ ଫୋପାଡ଼ି ଦେଇଥାନ୍ତା କୁଆଡେ ପାଣି ଭିତରେ କୁଆଡେ ଫୋପାଡ଼ି ସିଜ ହେଇନଥାନ୍ତା ବହୁତ କେସରେ ବି ହୁଏ if the evidence of the witness is believable eyewitness whether mere non-recovery of the witness that weapon of offense would be a ground to throw the evidence of the prosecution if it is otherwise acceptable. So ନାଇଁ ଏଠି ଆପଣଙ୍କର ଦିଟା evidence ଦିଟା injury ଦେଖଉଛନ୍ତି ଯୋଉ ପାର୍ଟରେ କି ଆଇ ୱିଟନେସ୍ କହୁଛନ୍ତି ଆପଣ ଅସିପିଟାଲ ରିଜିୟନରେ ଗୋଟେ ଅଛି ଏବଂ ଚିନ୍ ପୋର୍ସନ ଯୋଉ ନେକ୍ ରେ ପୋର୍ସନ କହିଛନ୍ତି ଦିଟା ଯାକ ଇଞ୍ଜୁରି ଅଛି ସୋ ସାର୍ପ ସାଇଡ ଜଣେ କହିଛି ଆର ଜଣକୁ କିଛି କହିନି
ପୋଲିସ କହିଛି ପୋଲିସ କହିଲା କାହାକୁ କୋର୍ଟ କରିଛି ସାର୍ପ ସାଇଡରେ
କିଏ
ପୋଲିସ
PW1 PW10 କଣ ସେ କିଏ
ପୋଲିସ
ଆୟୁ କଣ କହିବ ମୁଁ ସାର୍ପ ସାଇଡ ୟୁଜ ହେଇଛି PW1 or 9 they are the best person because they were 9 আসে যদি 8 কহিলা যে এক্সামিন করিকিনি যে these are the injuries possible ଆପଣ এই ଯୋଉ ଜେନେରାଲ କ୍ୱେଶ୍ଚିନ୍ସ ପଚାରିଲେ ଜେନେରାଲ କ୍ୱେଶ୍ଚିନ୍ ସେଟା ତ ଲେଖା ହେଇଛି ମୋଦି ଜୁରିସ୍ପ୍ରୁଡେନ୍ସ ନାଇଁ ନାଇଁ ସିଏ ୱିଟନେସ ଏକ୍ସାମିନ କରିସାରିଲାଣି ଯେ ଆକ୍ସକୁ ଏକ୍ସାମିନ କରିକିନି କହୁଛି ଯୋଉ ଇଞ୍ଜୁରି ମୁଁ ଦେଖିଛି ସେଇ ଇଞ୍ଜୁରି ପସିବୁଲ ଏଇ ଆକ୍ସରେ ହ୍ୟୁମାନ ବ୍ଲଡ ଆସିଲା ଆପଣ କଣ ପଚାରିଲେ ଯେ ଡିଫେନ୍ସରେ ମାନେ କ୍ରସ୍ ଏକ୍ସାମିନେସନ ଯେ ଲାସେରେଟେଡ ଉଣ୍ଡଟା ଇନସାଇଡ ଉଣ୍ଡ ହବ ସାର୍ପ କଟିଂ ୱେପନରେ ଠିକ ସେଟା ମୋଦିରେ ଲେଖା ହେଇଛି ଲାସେରେଟେଡ ଉଣ୍ଡ ହବ ମାନେ ବ୍ଲଣ୍ଟରେ ହବ ଠିକ ଅଛି ସେଟା ଲେଖା ହେଇଛି କ୍ୱେଶ୍ଚିନ୍ ହଉଛି ଯେ when he has given a positive opinion and you are not bringing anything on record that his opinion which has been given as per the query made by the IO is not believable in view of this evidence. Modi's jurisprudence or Taylor jurisprudence हो ତେଣୁ ଏଠି ଆପଣ ତାକୁ କରୁନାହାନ୍ତି ଖାଲି ଜେନେରାଲ ଦିଟା ଲାଇନରେ ପଚାରିଲେ can the entire chief examination of the doctor that these injuries are possible by this weapon will be disbelieved or can that be a ground also to disbelieve the eyewitnesses version ଯେ ଯୋଉ eyewitness କହିଛନ୍ତି axe ରେ injury ହବ ଡକ୍ଟର ବି କହୁଛି axe କୁ examine କରିକିନି these injuries as possible ଆପଣ ଦିଟା ଲାଇନ ଖାଲି ପଚାରି ଦେଇଛନ୍ତି ଯେ lacerated wound ଏଥିରେ ହବ ଏଇଟାରେ ହବ ତ it's all right that is the general thing ମୋଦି jurisprudence ଅଛି ସେ ବିଷୟରେ lacerated wound ହବାକୁ ହେଲେ blunt use ହବ ଆଉ sharp cutting weapon ହେଲେ usually incised wound ବା cut wound ହବ these are the general but can that be a ground to disbelieve the evidence of this doctor's opinion or the evidence of the eyewitness?
Getting the use of particular acts. That seems it is the evidence that it is commonly available. Second is that it not sealed as per the Malkhana register is not there. Third is before minors that the blood is there. Mind group it is not getting.
Seizure କୋଉଠୁ କଲା ଆୟୁ
ତାଙ୍କ ଘରୁ 27. ଆଜ୍ଞା 27 ରେ further ଆଉ ଗୋଟେ
please come to that line you have not placed the IO's evidence let us see that from
Loss. Total 10. Yes, 59 days. On 6/3/7, I was working at SI of police, but Southern PS Sugarloaf. On that day at 9:45 p.m., IIC Permanent Sahu received the written report from Information of Odin Bolama regarding the Bianca. Some so by Golden I can of that. Basing on the said report, IIC registered this also and one of them and directed me to take up the investigation. This is the said report received by the IIC. Wherein the executive the team of formal affair mark executive 1, 4 and 1, 5 in the signature of IIC on it with whose handwriting and signature I am well acquainted in my official capacity. During course of investigation, I examined the informant and the scribe of the report Suresh Munda and I recorded their statement under section 161 At 10 p.m. IIC issued command in favor of Constable NH to proceed to guard the this is Dharan Kumara. This is the command certificate dated 13/31. Signature at 11 p.m. I along with the IIC arrived at the spot. I visited the spot and prepared the spot man. Mark the executive copy. The appointment on the time. I examined the one, yes, namely Vijay Kisan, Lakshman Kisan of Unipura, Kalia and Dhaneshwar Kisan, recorded their statement also sought for the on 7/3/7, I further examined witness number Saroswati Naik, Namita Naik, and the recorded statement of the section 161 CRH. I also sent requisition to scientific team to examine the spot at 9:30 a.m. I see the blood-stained air and sakura on the spot in presence of witnesses and where the cigarette marked the exhibit, wherein the exhibit to I examined the cigar witnesses at 10 a.m. I had inquest over the dead body in presence of witness and prepared the inquest report for and executive put in my signature on it. At 11:30 a.m., I dispatched the dead body for its postmortem examination. Dead body Charan along with along with further command in favor of Constable Sir. This is the dead body Charan my signal 3 p.m. I apprehended at 14 the night along with Tomlin and arrested them after observing all the formalities while in police quarters. Atul Govinda voluntarily gave information regarding concealment of gas, crime weapon inside the thatched roof of his house to me in presence of witnesses and further disclosed that he will be accompanied to the spot to the recovery of the same. It is recorded on the section 47 of the Evidence Act, presence of the witnesses and obtained their signature along with the signature of Atul Govinda Naik. This is the shared statement marked my signature. Pursuant to his statement, he led me and witnesses to the place of concealment. They asked his house and gave recovery of the crime weapon stained with blood from under the thatched roof of his house in presence of witnesses which seized and seized scissor list marked I placed my signature on at 5 p.m. I see the wearing apparel subject of such as one cement color gold tank on brown color projected in presence of witnesses. And prepared a scissor list marked 6 to 160 my signature on it. At 5:30 p.m. I see the wearing apparel survived in the night, such as this green color of the pant, this orange color shirt stained with the blood, this green color blazer from the position of accused in presence of witnesses, and prepared the scissor which marked Exhibit 7:1 and 7:3 is my signature on it. At 7:30 p.m. I see the wearing apparel of the this is after PM examination on production of Constable Warrior order such as this black colored brown footwear, this ash colored underwear, this ash colored boxer stained with blood, this blue colored banyan stained with blood, along with his command certificate in presence of witnesses, and prepared his scissor which marked Exhibit 9, wherein Exhibit 9 to be my signature. This is the art already marked in one. This is the green color footprint of Bible window. Like mark MO2 and MO3 is the orange color filter. MO4 is the green color onion. 5 is the black color woodland. So this is MO6 is the ash color underwear. MO7 is the ash color shark. 8 is blue color banana. On 837 on 10:15 a.m. I sent the accused person for collection of their nail clips and blood sample and received the report. I seized the blood sample and nail clips of both the accused person in favor of separate seal packet, along with the common certificate and prepared the seal mark and the agreement 10 to signature on 2 p.m. I forwarded the accused person to 23/7. I received the PM of Dr. Swan. So I issued a requisition in favor of Dr. for exemption of the acts, along with the answer to the code. This is the requisition marked at 2 and 2 my signature. I received the report from report due to my illness. I remained absent, for which charge of this case was taken over by the ISC S.K.SAHOO, who again re-examined the witnesses. I have examined Dhaneshwar Kisan Petrol 5. He has stated before me that while Atul Govind was in police custody, gave information to police in his presence and the presence of Suresh Munda regarding concealment of the Puya inside the captured S.K.SAHOO, and that further disclosed that he will be accompanied to that place. He will give recovery of the same, and that police recorded his statement under section 47 of Evidence Act of Parity to his signature, and that pursuant to his statement, Govinda led police along with them to the place of concealment and gave recovery of the same. I have examined the solution to PWC. He has stated before me that after feeling her to slap, horse from holding a body and holding an axe went outside, and after some time he heard that I could bring the act Dharani violence of the said act, and that thereafter they would home along with the Ganga, and therefore Govinda always left for the process. After seizure of the axe, I had wrapped it by paper. I have not obtained the signatures of the witnesses, as well as the accused on the sealed acts, so also over wrapped paper. The acts were kept inside the police Malkhana, private Malkhana number 7. I have not sealed the Malkhana register in connection with this case. I have not sealed the wearing apparatus of the accused and the deceased, but I have separately wrapped them by separate paper. I have not obtained the signature of the witnesses and the accused over the sealed cross. Acts like the MO1 is commonly available in each house of the village. I arrested accused Govinda Jungle. It is not a fact the accused has not given any information voluntarily regarding concealment of the acts in the house, and pursuant to his short statement, I see the acts. It is not a fact that on my instruction the witnesses put their signature on the statement as well as on the seizure list. It is not a fact that I have not seized the wearing apparatus of Window at the instance at the place. Thereafter, there are houses of Kalia, Dhaneshwar Kisan, Gokul Kisan, Sodami Kisan, others situated near this spot. I have not examined Gokul Kisan, Sodami Kisan, Soimu Kisan in this case. In my acquisition, while sending the same to the doctor for examination and answer to my query, it is not a fact that my investigation is perfunctory and that I have produced all the documents against that. Thereafter was committed the charge sheet in PW level. The other police officer who has taken over the charge and re-examined the witnesses, and he has submitted that. And this is Saraswati and Kalia Kisan. They have been turned hostile. That Saraswati and Kalia Kisan. But I have been in their hostile. But I have illustrated during cross-examination defense. They have said that nothing has been said regarding concealment of the acts, and they have not led the police. These two things are in the mouth of the PW5 and PW2 and 5, who is the scribe of the affair and also witness to the inquest and also witness to the statement under section 27. PW5 is the father of PW1, the Kalia Kisan, and he also says that he is the witness to the seizure, witness to the inquest, and witness to the statement under section 27. They have resumed the statement given by them. Said that nothing has been said. So police has cited these two persons as witness to the, they have been declared hostile. So far the other party is concerned, but what we have elicited, they have said that nothing has been said before the police by the accused that I have concealed that. So regarding that, 4 points before your lordship, this particular act was not used, that it is commonly available, 1-2 cases are saved, and it was not properly police said that Afghana registered, it was not properly said. My lord's quoting perhaps 437 or 237, lordship's decision that it is to be placed, it is to be entered, while taking away, it is to be again entered, all these things. And it was sent to for chemical examination, the blood has deteriorated, and it would my assumption before it would come to the benefit of the act. So it is there, human blood, my blood group might have been taken, but it is not matching. That is not there. That could not be made possible. And seizure my lord 27 my lord, these 4 things regarding it. And the use of the acts, the inconsistency between the medical evidence. Now, the way my lord proceedings are no suggestion, but I bow down to your lordship, but kindly consider totality of circumstances. This is the position. Then, one more point I want to say.
So availability of Tangia in village, in every house, according to you, will exclude the point of
Use of that particular fact.
particular,
It is planted by some, not pre-process.
or there is no premeditation.
Fact.
Yes. Yes, proceed.
Yes.
My lord, one more point before loss. I will just say 2 points. Then one more point, my lord. There are 2 accused persons. Charge is 302 to 32. One has been acquitted. My solution is 34 tails. 34 tails. And there is no independent charge of 302. But conviction is under section 302. I was searching for decision. I got one decision that where charge is equal to 149. There, Honorable Supreme Court 55 Supreme Court has held that this is incurable infraction, cannot be cured, and acquisition.
No, 302, 149 is different.
149 distinct offense, 34 is not an offense.
Because that requires about 5 or more.
Unlawful assembly is one of the criteria.
Here 34 tells because charge is 34. And it will in the fact that one person, no question of 34. So one person, but no charge of 30. Conviction is under 30. Before I want to consider. But I wanted to get the decision because yesterday.
No, that is decision against you is there. If
one decision only you will find with that in that regard, that is of long back, but Supreme Court has already taken.
Suppose 302 is there, 326 can be taken. But
no. Even in 302, 34, acquittal of one of the accused, one of Justice L. Mahapatra and Justice P.K. Tripathi had given one judgment where 34 was not there. It was Supreme Court has taken note of it.
34, my details to one way. Only 302 depends in another way. Cannot be said. So I am prejudiced because no defense could be able to. I could not lead my defense. Had it been 302, my defense would have been otherwise. Had it been 302, I have given my defense. So for 302, 34 is concerned. But no independent evidence. 302 charge has not been transferred to. I am not to charge with the other 302. My defense your lordship kindly rightly your lordship. Who gonna point that? 302 is all that কথা.
But is it your case that you are only in furtherance of common intention?
No, only for the contract. It is shortcut picture. 302. Against people who
this very particular point was raised in many cases that used to be in Supreme Court that charge was not there. So
55 Supreme Court ଗୋଟେ line କହୁଥିଲେ ଯଦି 302 149 302 34 is a wrong condition.
That is a different concept altogether. There the question of common object is there. Here the question of sharing common
condition ଯାହାର ରୋଲ ଯାହା ହେଲେ ବି ଅନ୍ୟ ଜଣେ ଲାଇନ୍.
Yes.
ଆଜ୍ଞା ଏଠି ତ ଯଦି କମନ ଇଣ୍ଟେନସନ ଟା ପ୍ରୁଭ କଲେ ମୋର କମନ ଇଣ୍ଟେନସନ ନାହିଁ ମୋର ଇଣ୍ଡିଭିଜୁଆଲି ଦି ଜଣ ଆସିଲେ ଗୋଟେ ବାଡି ଆଣିଛି କି ଗୋଟେ ଇଏ ଆଣିଛି ମୁଁ ମାରିଲି ସିଏ ଯଦି ଚାଲିଗଲେ ମୁଁ ଯଦି ଏକା ଥାନ୍ତି 302 ତା ଚାର୍ଜ ହେଇଥାନ୍ତା 334 କଲେ ଆଉ ଗୋଟେ ଚାର୍ଜ ବି କରିପାରିଥାନ୍ତେ 302 ସ୍ପେସିଫିକାଲି ଟୁ ମି এটা তো ହେଇନି whether I have for minors to consider or the खाली raise
they are giving the series of decision to you. You may go through it.
ଆଜ୍ଞା ବୋଧେ
But this matter has already been settled.
Lastly, my alternative for a lesser punishment. My lord, I am confined to 3 things. Your Lordship, there are eyewitnesses, 2 eyewitnesses, blows are 2, and no intention. यही परिप्रेक्षी में गोटे डिसीजन दौची जदि 10 years मो भीतर रहिले तापर बेल ले जाइछि 8 रो अपरांश 18 रे बोधे बेल ले जाइछि तेणु 10 वर्ष मो रहिछि आ 22 23 वर्ष रो ये सेटल अपरांश बेले पतन जहा है तो जदि लाइफ रे रहिछि हदर मु कंसीडर द लेसर ऑफेंस जदि 10 वर्ष रहिले
same contents of Mr. Lori and the the 464 CRPC general consideration that it cannot be that this is
Consistent or telling out.
जो ये रहती 302 contract is executed except the appellant, whether the appellant can be convicted under section 302 LES. This one. Pal Singh versus State of Punjab. Two accused convicted under section 302 so or by so two accused acquitted under accused. One can be convicted under section. Charge. One. This is the P over 7. One. P for PLI करो वो कर PLI तभी कट होगा CIT हुआ PLI TI तो T होगा charge under section charge of all and only the conviction the constitutional bench of the subject that usually because a charge has not been sent or the conviction not be recorded unless prejudice has been shown. And this will be factor which is depend on the facts of each state. The person noted for charge under section field and that particular opinion as the constitutional office. The opinion matters that will have charge under section from the as to use also that will but constitution then section 51 fundamental charge at the alternate of section the consequence response the exclusion of the final that was not here. Sentence grounds on the ground on the ground of error, omission, or irregularity. First problem is a state of UP that on the case of number of accused persons charged with fixing on the accused persons are executed under 49 can disclose the appellant and himself made an attempt on flight himself sought unlimited upon convicted and necessity. I don't know. For this kind of question was previously and then prospect turning question conclude possible discussion is the end of some characters of this one. So I know that Sham rate of another case the charge in section 302 and 149 condition of 302 temperature without any separate charge on the section just convicted and sections also charge is not common intentional to provide the responsibility. Now to discuss on it. Now it is true that there are observations there without to support the council for the purpose of the political construct in the light of the facts found for crucial fact and prejudicial response from the appellant was dismissed evidence and factors taken consideration again the person who will be the father and who was hard also that it is him that he was for the first committed by his personal but only like very good for another dominant an object of the person she was but that was one of the matters considered the DLP is full division confidence and learning strongly are more self-organizing and not that not approach attention being wrong to the actual people problem. Yeah, you know, so that and the wrong one. Now you can then benefit of from the part of the actually how we turn to the question. Then actually in this case on the software defining of the two term large three and three to two dimensions from the near product. On the number level, yeah, it's cool. But all the activities taken to charging for charging is forms sort of only can come to things documents out of which is small section or particulars in the time free personal instrument is committed in nature of the case in such that the particulars do not give sufficient notice of the matter which is charged and such particulars also is not then for the issue charge. He probably 200 also he is accused of murder of the given time and the charge may not still manner a murder. It is clear from this that when the case is on and that there is not to be told the charge how it was committed or whether it is told or not here is not entitled to know from the charge in particular any further circumstances how we make sure then already since the prosecution has been examined the sections also in the proceeding necessary in the critical information and it is in general decline itself. See how we can time also and is delivered and that several persons join in the commission of the crime say are community is that each one can be requisite intention with himself and that the other share does not observe in any individually and when the crime actually committed in persons and common intention is present at its commission the crime becomes an offense actually committed from section 114 of the Evidence Act. Section 114 is not done section 32. These sections announcing the criminal and therefore the details of the occurrence. This conducting in such cases, all that the charge in to set out the offense of murder from 7 females committed by the accused and others. And the left together, the details of the occurrence are alleged in the prosecution from other sources. That it's told that his charge is not committed by himself and another proves that every legal information reflects and constitutes the offense of murder committed in case was portrayed. So, now, what is this? The according to the case of charging persons who committed in persons of the family, hence that the accused unmistakably told that he participated in the crime. Exactly how he is known by manual to the charge as set out in the circumstances in which the murder is committed. It also means that it is a material stroke of fatal. The artists are able to document and other things are identified and fatal as person victim. Put the charges, put and charge this way it can be. Each is put on guard and made to realize prosecution alleged that one of the two was responsible for that and which must be discovered from evidence and not from the charge. Just as surely as it must when the person term possessed or deal with pistol and sword. It is true. That it has certain good from common that way converse does not hold years. And the part of the accused plate can clearly brought and sufficient victim sufficient and not the escape liability for the charge for the unless it also 70 70 per annum. The addition is not responsible. Case number 116. certain decision, the Supreme Court that called So, Mr. The five judge bench decision that decided on this particular question, that was because of the divergent view of the in the Honorable Supreme Court, that matter was referred to the five judge bench, and this particular point was discussed, and they have stated that what should be there in the charge, and merely because individual charge is not there, or simple the 302 charge is not there. It is a case of two co-accused persons. They have been charged under section 302 by 30, where the specific role attributed is against one person right from the beginning, that it is the only one person whose blow is the cause of death, and that has been there in the charge. So in such circumstance, the accused cannot be said to be prejudiced. They say that unless there is prejudice, uh, merely because the charge has not been framed under section 302 simply sitter against a particular person, but it has been framed like 302 by 34, that cannot be a ground to uh, that line. They have very important finding, and that has been followed in hundreds of decisions throughout the country, but the Honorable Supreme Court at least followed it in number of cases. That is, has been mentioned. So the very relevant paragraph. ସେଇ ବିଷୟରେ ମଧ୍ୟ ଏଠି ସବୁ ସବୁ ଡିସ୍କସନ ହେଇଛି। ଆପଣ ଯୋଉ ପଏଣ୍ଟଟା କହୁଛନ୍ତି ସେ ବିଷୟରେ ମଧ୍ୟ ଡିସ୍କସନ ହେଇଛି ଯେ ମାନେ ଆପଣ ଯେ ଆପଣ ଯୋଉ କହିଲେ ନା ସିଏ ହୁଏତ ଅଲଗା ଟାଇପ ର ଡିଫେନ୍ସ ନେଇଥାନ୍ତା, ଇଏ କହୁଛନ୍ତି ଯେ ହଁ ପୋଲିସ ପେପର ଠୁ ଆରମ୍ଭ କରି ସବୁ ଇଏରେ କେହି କହୁନାହାନ୍ତି ସେ ଆର ଆକ୍ୟୁଜ୍ଡ ର କୌଣସି ବ୍ଲୋ ଦେଇଥିଲା ବା ଦ୍ୟାଟ ଇଜ ଦି ରେସ୍ପନ୍ସ, ଏବଂ ସିଏ ଆୱେୟାର। ଏବଂ ଆପଣଙ୍କର ଏଠି ଚାର୍ଜ ଟା ଦେଖନ୍ତୁ, କମ୍ ଟୁ ଦି ଚାର୍ଜ ଇଟସେଲ୍ଫ। चार्ज रे डेट एंड टाइम अच्छी जोटा की रिक्वायरमेंट अच्छी, प्लेस भी रहिला पेज 29, furtherance of the common intention vision committed murder of intentionally by causing death of this one, so deceased na rahila, assault him on his head and neck, body part rahila. So everything, all the details have been mentioned. So if he apankara not only what they say that when police papers were supplied to you and when this type of charge is framed, evidence madhya sei light re adduce kar jai chalchandi witness mane, at least data witness, then it is you who has given that blow, non knowledge। ତେଣୁ ଏଠି କୁହାଯାଇ ପାରିବନି ଯେ ଆପଣ କୌଣସି ମାତ୍ରାରେ ପ୍ରିଜୁଡିସିଆଲ ତେଣୁ ସେଥିପାଇଁ omission or error in the framing of the charge as per section 464 that would not vitiate the trial unless it has caused prejudice. That is the language of 460 that they have also taken into account.
And they say that it is not from the charge but from the evidence issues.
Punishment.
How can it
Lesser
be?
punishment could be possible only when it comes under the exceptions.
Two blows, one is on the head, causing fracture, brain matters. You know that what has been stated. The other is on the neck. Injury sufficient in ordinary course of nature to cause it. Amaku, unless we bring it under any of the exceptions as enumerated under section 300. पांचटा exception अछि से पांचटा exception भीतर को आसिले प्रश्न होबो culpable homicide not amounting to murder 304 part 1 हो कि 304 part 2 आपण को आनिबा को ता भीतर exception एठी किछि नाही.
Where they have said two eyewitnesses there, two injuries are there, there is no intention to be gathered from the circumstances.
Intention ता जणे केमती गैदर करी आपण गोटे नॉर्मली इंटेंशन होउची आपण को टाइप रो वेपन यूज करछंती को बॉडी रो को पार्ट को यूज करछंती तार आपणकर कंडक्ट आफ्टर द प्रायर टू द ऑकरेंस एंड आफ्टर द ऑकरेंस इगुडा को दीज आर द ऑल द मैटर्स फ्रॉम व्हिच योर इंटेंशन कैन बी गैदर्ड. then when you are going to your house bringing the axe dealing two blows on the most vital part of the body like head and neck and the impact of injury is such that it is causing fracture of the your occipital that bone and affected the
Vessels
right. So how can you say that you have no intention when the law is that intention has to be gathered from these materials? How can you say? Judgment upon सुनो इसे प्रत्येक केस रो फैक्ट ऊपर रेशियो कौन हबो ताइटा डिपेंड
In this case, the judgment which has been passed by the court below, nothing has been gathered from the attending circumstances relating to the intention. और किछि intention नहीं. Suddenly जने appear ताको सागर काम करिया को जानती, सकाळ संध्या रे जानती, सेदिन दिन सारा रहिचंती, सकाळ संगे संगे PW1 देखिले ये आसी के मार देला. तो लक्ष्मी this is the stray line. तापर पूर्वुर परे किछि नहीं. ये लक्ष्मी काहे से आ किछि नहीं. 10 years ପରେ ମୁଁ release ହେଲି 11 years ଖଣ୍ଡେ ରହିଛି. There is no intention. That is permitted. No intention.
Enter to a decision level देखियो this 56 Supreme Court 116 that has been followed by Supreme Court on the decision latest decision form 3034 acquittal 8/34 equity implicit conviction 8/302 so whether it is permissible or not comes to permissible constitutional bench decision is permissible so after latest data will find it out कौन सा कंडीशन
आनिछि कि 2007 38 OCR
ये बाहर को बना अच्छी बॉय अच्छी 2007
bracket ends 38 OCR Supreme Court 816
OCR 816 Supreme Court decision
yes
पढ़ो से बॉय बाहर को वो पैराग्राफ कौन
appellant got injury and picked up an iron injury lying inside the room and administered blows
आपण देखो एतिकी रे केते डिफरेंस আছে appellant was assaulted प्रथमे सी assault he picked up a thing ସେଇଠି ପଡିଥିଲା ତାକୁ ଉଠେଇଲା या ଭିତରେ ଆଉ ଏଇ जो फैक्ट रे appellant ना किछि इंजुरी अछि से रादर से घर को जाइकिनी नेइकिनी आसुची या भीतर पार्थक्य नहीं तो ସେଇଥି ପାଇଁ कहउची प्रत्येक एक्ट आपणकर माने रेशियो को चेंज कर दो तेणु
that is right way. He picked up it sudden provocation. He got a jolt from the appellant appellant was taken to task first, then he picked up the
deceased ମାରିଥିବ ତା ଦେହରେ injury ହେଇଥିବ ତାପରେ ପାଖରେ ଗୋଟେ ଜିନିଷ ପାଇକି ଠେଲା ମାରିଲା
that is what
different ଆଉ କିଛି ନାହିଁ ଆପଣ ଘରକୁ ଯିବେ ତାକୁ ଆଣିବେ ତାର ଦିଟା ବ୍ଲୋ ଦେବେ
ଗଲେ ବି in connection with I took Saraswati PW7 ଯିଏ ହଉଛି aunt of ଅଭି other co-accused person ଘରକୁ ଗଲେ ଘରେ ଅଭି ଆଗରେ କହିଲି ଅଭି ଯୋଉଟା ଚାପୁଡା ତାର ନିଜ ମା ମୋର କିଛି ରୋଲ ନାହିଁ ଆସିବା ବାଦେ ମୁଁ ଯେ ସେଇ କନେକ୍ସନରେ ମାରିଲି ସେ କଥା ନାହିଁ ମୁଁ ଆସିଲି ମାରିଲି
all right which paragraph you want to just tell the paragraph we will verify that decision which paragraphs according to you are relevant
paragraph 7
yes
16 and 17
any other decision
2002 OLR Supreme Court
2002
OLR
1
2
volume 2
OLR Supreme Court
yes
618 ଏଠାରେ କେବଳ
ସେ କଣ କହିଲେ
ଏଠାରେ ସିଏ ମାରିଲା two blows are there eyewitnesses are there but no intention not the case
କୋଉ paragraph को discussion
paragraph ଏଠି ଲେଖା ଅଛି 2 to 8
ଆଚ୍ଛା 2 to
ମୁଁ ଯୋଉଟା ପଢିଛି 11 ମାର୍ଚି ସେଟା ଲାଷ୍ଟ କୁ page 622 ରେ ଅଛି paragraph 7
first second ଅଛି first या ଦୁଇଟା ଦିଅ just pass on that ନାଇଁ second ଟା ଯୋଉ
second
ଏଟା 2002 ଟା ଦଉଛନ୍ତି ତ
ଆଜ୍ଞା page 622 paragraph
not discussed in that manner. Say that there was no intention or motive that is in that light is stated like that. Yes, Mr. Tripathi. All right, all right. All right. Yes.
In this case, only this appellant test trial and other accused is juvenile. What happened?
No, it's all right.
But here it is alone.
Yes.
No, this case, in that charge also the name of the other accused has been
Yes.
mentioned.
Yes.
It's that অভিনয় juvenile সহিত common intention share করলে বেলি মধ্যে উল্লেখ আছে.
Yes.
So whether he has been acquitted or not, that's a different thing. But the date and time, place of occurrence, and the person, the name of the deceased, assault part on the body part where the assault, everything is mentioned in the charge. Yes.
And the time segment is there, 7:30. That may be different from 5 minutes, 10 minutes, but because they are the labor person, they have no watch.
No. How do you the submission, the first submission has been made that there are two eyewitnesses.
Yes.
One is PW1, the other is PW9. So when two eyewitnesses are there, Mr. Das says that since the other eyewitness PW9 says that there was nobody around the spot except the appellant and the deceased, then how can the presence of PW1 be accepted that he was present and saw? That is his first submission.
This PW9 may be standing back to the back of that PW1.
Okay, the position.
Nobody. And because PW9's house is, kindly have a glance to the spot map.
Yes, spot map is
74.
Yes.
The house of Lakshman Kisan.
Lakshman Kisan is
towards north.
Spot টা তো এটা দেখিয়েছি অরিজিন পড়ছি এবং
spot-টা 8
হ্যাঁ spot-টা 8 that is also there in the inquest report যে PW আচ্ছা এইটা হচ্ছে লক্ষণ হচ্ছে PW9
yes
ଆଉ ଇଏ ଧନେଶ ଏ ଯୋଉ କାଳିଆ ହଉଛି PW1
ନା କାଳିଆ ହେଲା ବିଜୟ
ନାଇଁ କାଳିଆ କିଏ ମାନେ
ଲକ୍ଷ୍ମଣ ହେଲା PW9
ହଁ ଲକ୍ଷ୍ମଣ ଆଚ୍ଛା ସେଇ ଏକା ଘର ନୁହେଁ ମୁଁ ସେଇଆ ହିଁ କହୁଛି ମାନେ so the and inquest report also it is mentioned that the dead body was lying in front of the that is in Kalia. So that is correct. So now you mean to say that when the PW9 was in the front of his house, so he is in a better position to mark who was closer to the deceased. So that is how he has mentioned sorry, that is how his case is that he could have noticed both of them when they were standing close to each other. How he missed it, that is his submission. ଆପଣ ପୋଜିସନ ଟା ଦେଖନ୍ତୁ PW1 ର ଘର ସାମ୍ନାରେ ଏ ଘଟଣାଟା ହେଲା ତ ସେଠି PW1 ଆଉ ଡିସିଜ୍ ଥିଲେ ଏ ଜାଗାଟାରେ PW9 ଥିଲା କୋଉଠି ନା ସେ କହୁଛି ପାଖରେ ଲେଟେଷ୍ଟ ଏବଂ ତା ଘର ସାମ୍ନାରେ ତେଣୁ ହୁଏତ PW1 ର ତାକୁ ନୋଟିସ କରିବାର ଦେଖି ନପାରେ ବଟ୍ PW9 ର ନୋଟିସ କରିବାର ବହୁତ ଜଷ୍ଟିଫିକେସନ ଅଛି he was in a better position ଯେହେତୁ କ୍ଲୋଜ ଇଏ ରହିଲା
at the time of occurrence this PW1 is not in front of his house.
ଘଟଣାଟା ପରେ ତା ଘର ସାମ୍ନାରେ ହେଲା
ଘର ସାମ୍ନାରେ ହେଲା
ଆଉ ସେ
he was not in the house. Not in the house.
No, he was returning
from where? ଏପଟୁ ଯାଉଥିଲା What's not?
ତା ଘର ସାମ୍ନାରେ ଘଟଣା ହେଇଛି, ରାସ୍ତା ଉପରେ ଘଟଣା ହେଇଛି, inquest report ମଧ୍ୟ ହଉଛି
Yes,
ରାସ୍ତା
yes,
ଉପରେ,
that is
right?
Yes.
So his submission is that PW9 as evidence falsifies the presence of PW1 at this.
Has not seen that one or other person.
PW1 to अन्य person chhade. Then next his submission is that so many houses are there as has been elicited in the cross examination. So only the other persons have not been examined. Number one. Number two, the persons who reached at the spot.
They are not.
According to PW1, 2 persons at least reached at the spot. Right. They have not been examined. That is his submission. So what do you want to say on that?
There are 2 eyewitnesses.
That is sufficient. According to you, that is sufficient. If that evidence is not.
Yes.
Then his main submission is that this weapon which was seized at the instance of the appellant, that was not kept in a sealed condition, and it was just packed in a paper,
wrapped in a
paper, and it was sent. And the doctor has also stated that ମୋ ପାଖରେ ଯେତେବେଳେ ପହଞ୍ଚିଲା ଖାଲି ଗୋଟେ ପେପରରେ ଗୁଡା ହେଇକିନି ଥିଲା ଏବଂ ସେ କହିବା କଥା ତାଙ୍କର ସବମିଶନ ହଉଛି ଯେ ଆପଣଙ୍କର ଏ ଟାଙ୍ଗିଆଟା ଟାଙ୍ଗିଆଟା ସିଜ୍ ହେଇଛି 7 ତାରିଖ ଦିନ 7/3/2007 ଯୋଉଟା କି ସିଜିୟର ଲିଷ୍ଟ ଇଣ୍ଡିକେଟ କରୁଛି ହେଲା ଡକ୍ଟର ପାଖରେ ପ୍ରଡ୍ୟୁସ ହେଇଛି 23 ତାରିଖ ଦିନ 23/3 ଅର୍ଥାତ 16 ଦିନ ପରେ 16 days. Evidence of IO says that it was kept in Malkhana entry number ଦେଇଛନ୍ତି ତାଙ୍କର ସବମିଶନ ହଉଛି ମାଲଖାନା ରେଜିଷ୍ଟର ପ୍ରଡ୍ୟୁସ ହେଇନି କୋଉ କଣ୍ଡିସନରେ ରହିଲା ଏଭିଡେନ୍ସ ନାହିଁ ଟ୍ୟାମ୍ପରିଂ ହବାର ବହୁତ ପସିବିଲିଟି ଅଛି ତେଣୁ ଇଏ ହଉଛି ଗୋଟେ ଆସ୍ପେକ୍ଟ ତେଣୁ ଯଦି ସିଲ୍ କଣ୍ଡିସନରେ ନ ରହିଲା ତାହେଲେ ଏବଂ ସେଇଟା ସି ପାଇଁ ଗଲା କେମିକାଲ ଏକ୍ସାମିନେସନ ପାଇଁ ଗଲା 3/7 ରେ ଅର୍ଥାତ almost after 3.5 months thereafter ତେଣୁ ଏଇ circumstance ରେ no importance is to be attached merely because human blood was noticed on it କାରଣ ଏକ ତ ଆପଣ ତାକୁ sealed condition ରେ ରଖି ନାହାନ୍ତି right ଏବଂ ଡିଲେ ଯୋଉ ହଉଛି ପ୍ରଡ୍ୟୁସ କରିବାକୁ ମାଜିଷ୍ଟ୍ରେଟ ପାଖରେ ତେଣୁ ଆପଣଙ୍କର ପ୍ରସିକ୍ୟୁସନ ଏଇଟା ହଉଛି ଏଭିଡେନ୍ସ ଯେ seized weapon should be kept in proper condition, sealed condition before it is being examined, produced in court and examined by the seal. ତେଣୁ ଆପଣଙ୍କର ଦାୟିତ୍ୱଟା ଖାଲି ମାଲଖାନାରେ ରଖିଲା ହେଲା ବୋଲି କହିଦେଲେ ଏଇଟା ଆପଣଙ୍କର ସବୁ ସରିଯିବ ନାହିଁ ତ ଏଇ ଏଭିଡେନ୍ସ ଉପରେ ଆପଣ କଣ କହିବେ ଏଇ ଯୋଉ 27
that is not their case where they have not suggested or asked question in cross examination
କଣ କାହାକୁ ପଚାର
ask
ଉପରେ କାହାକୁ ପଚାରନ୍ତି
କାହାକୁ ପଚାରନା
ଆଇଓକୁ ପଚାରିଥାନ୍ତେ ଆଇଓକୁ କ୍ୱେଶ୍ଚିନ୍ ହେଇନି ଆଇଓ କଣ ସଜେସନ ଦେଇଛନ୍ତି ଟିକେ ଆସିବ
that put question to the doctor.
Yes, doctor को भी पचारना
ना
doctor को पचार
there is no question.
अरे डॉक्टर को देखो ना आई हैव पचारना ना बाकी आईओ को कौन पचारजन आईओ को सजेशन कौन 60 The axe was kept in police Malkhana by Malkhana Mal number 10 of 2006. I have not seized the Malkhana register in connection with the case. I have not sealed the wearing apparels and the deceased, but separately wrapped in separate paper. Acha. Axe like swansu is commonly available. Most important thing is that you have got 2 eyewitnesses. You should have also your prosecutor should have shown that weapon of offense to the MO1 टाकू से witness को मध्यम देखी ना तेणु PW1 ଆଉ 9 ଦେଖେଇବାର ମଧ୍ୟ ଥିଲା ସେମାନେ କହିଥାନ୍ତେ କାରଣ ସେମାନେ ଦେଖିଛନ୍ତି ସେଟା ଗୋଟେ ଲିଙ୍କ ହେଇଥାନ୍ତା but let us say that link is not there that ସେମାନଙ୍କୁ ଦେଖି ନାହାନ୍ତି but otherwise ସେମାନଙ୍କର evidence ଆସୁଛି ଯେ axe ରେ ମାଡ଼ ହେଇଛି axe recovery ହେଇଛି axe ରୁ human blood ହେଇଛି ବାକି ଯୋଉ missing link ଗୁଡାକ ରହିଛି ଏଇଥିରୁ ସେମାନଙ୍କର prosecution case କୁ total disbelieve କରିଦିଆଇକି acquittal ହବ କି ନାହିଁ ବାକି ହଁ next ତାଙ୍କର ଆଉ ଗୋଟେ submission ହଉଛି about that sharp side and the lacerated wound. Lacerated wound was found and the doctor has stated that it is possible by no doctor said that it is possible.
Yes.
So
one of the witnesses about the
sharp side, that is PW 8 or 9.
କାଲି ସେଟା ଦେଖିଲେନି ଜୁରିସ୍ପ୍ରୁଡେନ୍ସ ରେ କଣ ଅଛି ସେଇଟା ହିଁ ଅଛି
ଆପଣଙ୍କୁ କାଲି ଇଣ୍ଡିକେସନ ଦିଆହେଇନଥିଲା ଯେ ଯଦି ହେଡ୍ ରେ କୌଣସି sharp cutting weapon use ହବ it may not look like inside wound always or cut injury because of the bones are there. So it a lacerated looking injury that is there in that. Sharp side weapon ଯୋଉଠି ମାନେ flesh ଅଛି ନା ସେଠି sharp ଆସିବ cut injury ଆସିବ inside wound ଆସିବ but ଯୋଉଠି hard surface ରହୁଛି like head ସେଠି କଣ ହବ ଏଇ ସବୁ ଜିନିଷ ସେଇଥିପାଇଁ it was their duty actually that ଆପଣ ସେମାନେ ପଚାରି ନାହାନ୍ତି when the doctor has stated they have not even given the suggestion that these are the injury which is not possible by so and so by the sharp side एमाने से खाली कहि ଦେଇଛନ୍ତି ଗୋଟେ general ନେଇ ଆସିଛନ୍ତି ସେମାନେ ନେଇ ଆଇଲେ କଣ ଯେ inside wound can be possible by sharp side of the axe and lacerated wound cannot be possible by sharp side of it. It's a general thing. ताकि बाकी କହିଦେଲେ ଯେ you have not and what about the last submission which he made about the intention part?
If there is sufficient evidence, eyewitness are there. Intention
eyewitness ର ତ ଜଣା ପଡିବ ଯେ intention eyewitness ର version ଉପରୁ ଜଣା ପଡିବ ଯେ କଣ ଘଟଣାଟା ହେଇଛି କେମିତି ହେଇଛି ଆଉ eyewitness importance ନୁହେଁ କଣ ଆପଣଙ୍କର eyewitness version medical evidence nature of weapon use part of the body assaulted impact of the blow all these things pre conduct post conduct ଏଗୁଡାକ ସବୁ ଗୁଡାକ relevant ହବ intention କୁ judge କରିବା ପାଇଁ ତେଣୁ ଏଠି ସେ କହୁଛନ୍ତି ଯେ first injury ଟା ହେଇଛି left occipito-temporal region second injury on the chin then fracture ଅଛି occipital region रे and temporal bone of the skull and below that region there is laceration of brain matter bleeding inside the cranium cavity present cause of death is hemorrhage and shock and injury to the vital organ like brain and injury to the large vessel injuries are antemortem sufficient in ordinary course of nature to cause death. These are the statement of the doctor, main statement.
Prior to occurrence, there was a quarrel between these two persons. Deceased and deceased and yes, PW9.
I
am reading that news. Thoroughly seeing the aunt of Govinda Devi Jama asked her to provide coin. At this, a quarrel ensued between Govinda and Thoroughly and leaving them, I went to the house of client.
For payment.
Yes.
Then what he has stated? I did not notice Govinda there. Govinda means the appellant. At that time, while I along with the Dharani were talking with near the electric pole, where one electric bulb was burning. So not only the co-villagers, but presence of light is there.
Yes.
So at about 7:30 p.m., I noticed Govinda holding an axe along with Abhinay suddenly arrived there, dead axe blow on the backside of the head of the Dharani, and thereafter dealt the second blow on the right side neck, as a result of which he fell down on the ground with profound profuse bleeding, and thereafter seeing the assault out of fear, I fled away from the spot.
That is the quarrel.
But he left the spot and brought the axe with him.
He could not say that what is the cause of the quarrel, and
Any citation you want to place, Mr.? Okay. We heard Mr. J.R. Das, Land Counsel for the appellant, Mr.
and I have one.
Yes.
That BW7, that Saraswati land, she also told that.
BW7.
Yes, I was reading that also. I know that I was standing in the law, who is the son of my elder brother-in-law. I know the Bharani Umar deceased, who died on 1 year back on day of CORAM at about 5:30 p.m. While I had been to village in search of labor on the way to return, Bharani asked me for hunger. On my refusal, Bharani covered me and embraced me. At that time, accused Govinda, my nephew, came there and took me to my house. Govinda in my house told my son Abhi, Dharani outbreak my modesty, for which Abhi dared to slap on my cheek. Saraswati Langa says that Govinda bad would say. Yes, he can judge. That is the Saraswati Bhattale.
No.
That is the motive.
I don't know.
Yeah, proceedings on this.
According to you, this is the motive behind it.
Yes.
Because he embraced
And tried to outweigh the modesty.
the mother of Abhi, who was that juvenile, and of course the aunt of the appellant, and that is why when it was informed, then this occurrence has taken place.
Yes.
we are closing it.
Yes.
Yeah.
Or Mr. J.R. Das, declaring counsel for the appellate. Mr. P.A. Tripathi, and in additional standing counsel. Hearing is closed, judgment is reserved. So, Mr. Das, you made good effort. That's a good thing. But that should be the attitude of a counsel who has been engaged by this legal aid board. But I'm sorry to say that most of the counsel is not coming prepared thoroughly, because whether it is a jail criminal appeal or a regular appeal, once you have been assigned a job and the person has no money, that is why the state legal aid board is engaging counsel. So whether you get money or not, that's not important. Private, but you are defending. It's a private. It's a private. Of course, it's a private bill. No, it's a JCR. But telling that once you come prepared and argue what would be the result of the case, that's a different matter. But you get the satisfaction that I have done my best. That is the most important. I've also conducted a number of death reference cases that no money, but the satisfaction, it has taken weeks for preparation. But in some cases, I have succeeded. One case, death, it was acuted. So, no, that's thing is that what I am telling, that the satisfaction which you get, that is otherwise, if you don't prepare merely because we are handing over the brief to you, sometimes we are engaging amicus curiae, giving the brief, but when we don't see the effort of the counsel, neither thorough preparation nor any argument, just so that creates pain, that why we engage such type of person. All right, thank you very much for that.
Item number 1.
It's a bail application. Next.
Item 12.
Nanda, Prashant Kumar Nanda. You have received the case diary?
There is no connected matter.
All right.
This is the third round journey, my lord.
Yes.
Earlier occasion, your lordship has dealt with this matter and directed to renew the prayer. In the meantime, my lord, eyewitnesses have turned hostile, my lord. To that effect, I have also annexed the depositions.
Who are those eyewitnesses?
Lord, one Rajesh Das and another is Srihari Das. Rajesh Das, Lord,
It's PW1.
PW1 at page 15, my lord. He turned hostile, and PW2 at page 18, my lord, that is Srihari Das, my lord.
He has also not supported the prosecution case.
No, my lord.
And you are in custody since when?
Lord, since 6/9/2022.
Yes, Mr. Misra.
One more aspect is that this kid had given confession under section 27 leading to discovery of a knife. And the cause of death is due to stab wound, your lordship. So that knife is gone for medical examination.
Knife which was recovered at his instance and that has been sent for series.
Yes, sir.
That has not been received.
Not been received.
But let us say that that evidence ultimately comes.
Gotcha.
Witnesses support the prosecution case. About 27, and let us say bloodstain also found in that knife as per your C report. So what would be its outcome if there is no direct evidence regarding involvement of the accused in the crime except 27, if there is nothing and he is in custody, so
it will not tantamount to be a complete change.
Are the learning counsel for the petitioner and counsel for the state and counsel for the appellant notice sufficient?
Yes, notice has been submitted also attended appeal. On 16th
Mr. Jagabandhu Sahu.
None appears for the informant. Learning counsel for the appellant submits that and the petitioner approves this court for bail last time in CRLA number 80 of 2023 as per order dated 18/5/2020. The bail application was rejected and liberty was granted to the appellant to renew the prayer for bail. After examination of the eyewitnesses, approach this court in CRLA number 899 of 2020. Our order date was 10/1/2020. Liberty was granted. And then he again approached this court for bail in CRLA number 480 of 2020, which was also rejected as per order dated 18/5/2020. The learning counsel for the petitioner submitted that in the meantime, the two eyewitnesses to the occurrence, namely Rajesh Das and Srihari Das, have been examined in the trial court as PW1 and PW2 respectively, and they have not supported the prosecution case. And therefore, in view of the change in the circumstances, the bail application may be favorably reconsidered. So, Learned Counsel for the state, after going through the deposition copies of the witnesses supplied by the Learned Counsel for the appellant, though not disputed regarding non-supporting of the prosecution case by the two eyewitnesses, but argued that at the instance of the appellant, one knife was recovered basing on his statement recorded under Section 27 of the Evidence Act, and the knife has been sent for chemical examination, and the report is awaited. Considering the submission made by the Learned Counsel for the respective parties, the nature of evidence adduced so far in the trial court, since the eyewitnesses have not supported the prosecution case, taking into account the period of detention of the appellant in judicial custody, I'm inclined to reconsider the prayer for bail and direct the appellant to be on the allowed.
Item 3.
Because this item will also the whereabouts of the informant. Yes, whereabouts of the informant are not yet monitored. And the inquiry which was there in a connected matter, the office has not been able to trace out that time. So I asked the IOT and the IAC to send the complete case area again. Right, they will also comment next.
Criminal antecedent.
Criminal antecedent, years no criminal.
Okay.
But I mean, pardon.
Yes.
There one thing.
Yes.
Victim has been agent. I don't have giving but victim has been for 3 months. Because victim has supported the. On general, I have no.
No.
Yes, please. Present. So, filing the show cause after.
When State Council talked to you, communicated the order of this court, why you said that you cannot appear before this court?
So it can not,
You have not said so. You have not said so. You said that I am the IO of the case, and now I have been transferred. I have been promoted, and that's why I will not appear. That shows your adamant attitude. You want to create a black spot in your CCR. That can be done easily with the court's observation, and it will stop all these things for you, for your future. We are not fascination to see your face. We have to hear a bail application. Person's liberty is at stake. He has filed a bail application. We have called for certain instruction. You are not providing that. And when a direction was passed by the court to appear, you will say to the State Council, I will not appear in court. That is the version of the State Council. I am reading it out, what he has said. That he has intimated the IO of the case, namely Sudhakar Sahu OPS, who is now the DSP Saranpur Nayagarh, but he expressed his unwillingness to appear before this court. What you have stated? Whatever you have stated, that you are busy in law and order situation in connection with some political parties demonstration, you should have intimated the London State Council. Why did you say that you did not?
All at a sudden mother telephone is was like that office. Who case a form to matter also. Now, secret of mind is one meter to that. Otherwise, move appear curtains.
And what about this C report and producing the material object before the trial court?
Because C report has we have already completed the launch. On 4th of this month. The IAC is sending an officer tomorrow to collect, and it will be submitted before the trial court tomorrow.
What that C report?
No, it's complete already.
And what about the material objects? Along with the material objects, it will be produced.
Yes.
Who is that officer who will go and collect it?
First file inquiry from basic action, inquiry from.
So it will be produced by day after tomorrow. Since when you are in custody, judicial custody?
Since 13/9 to 5/21.
13/1/3.
13/9. There are no clear records. And this is a counter case of the one.
Don't argue on merit. In merit, your case has been rejected, and you are given liberty to renew the prayer after the victim's evidence is recorded in the trial court. And trial could not commence because of the non-availability of the C report and material objects. That is why they were asked to produce it. All right. As per the order dated 14/11/2023. Is 21/11/2023. Mr. S.K.SAHOO, SDPO Saranpur, Nagar, has appeared before this court in person and filed the SOPS, in which he has tendered unconditional apology. And in open court, he submitted that the same thing will not be repeated in future. The SOPS affidavit is accepted. The personal appearance of Mr. Sahu is dispensed with. Learned counsel for the state on instruction submitted that the inspector in charge of Vice police station is to entrust one of the police official to visit the SFSL Rasulgarh, collect the C report, source of the material objects, and produced it before the learning trial court, that is additional session just Padmampur, in special GR case number 65 of 2021 by 8th of December 2022. If the same is produced, the learning trial courts are do well to expedite the framing of the charge and at the first instance take steps for the examination of the victim. This matter in the second week of January 2024. If the victim is examined in the meantime, learned counsel for the appellant shall produce the certified copy of the deposition of the victim, giving copy thereof to the learned counsel for the state. Pre-copy of the order be handed over to the learned counsel for the state. Copy of the order be communicated to the learned trial court. Yes.
I have only petition in respect of Umakant Sahu.
The IF for interim bill stands rejected. Next. Yes, next. Item number 5.
Yesterday the notice has been served. The whereabouts were not, if you have the whereabouts yesterday the found it.
And you have received the case diary and criminal antecedent instruction.
I have copy of the equation.
Copy of the
Equation of I.
You have not received it.
No, I saw the.
Okay. You are serving now.
No.
And are you filing for the court also? These are all certified copy. Xerox of the certified copy. The Land Council for the appellant filed the deposition copies of the witnesses which are taken on record. Copy of the same also furnished to the Land Council for the state in court. The Land Council for the state submitted that he has received the case diary as well as instruction about the criminal antecedent, if any, against the appellant. And the notice on the informant was served yesterday. In view of the submission of this matter in the week commencing from 18th of December 2023. If in the meantime the informant enters appearance in this court is through any advocate, the wakalatnama be placed on record and the name of the Land Council for the appellant be reflected in the cause list. Yes, next.
Item 6.
May I please your lordship, my lord?
Yeah.
My lord, here the petitioner as the appellant next week.
हाँ 11 तारीख दिन আছে সোমবার।
Obligation.
Item 7.
Having the surrender certificate and custody certificate of the petition. Out of 10 years, 9 years, 1 month, 7 and even custody. Conviction on assessment completely included in this act. Also granted individual of 24, 7, 44, 8, 44, 8. The period of 2 weeks.
Which matter you are moving now? There are
3 months, 4 of 44.
first one. Which order you are granted interim bail?
24, 8, 44. Order number 30. The number 201 of
So here the sentence imposed is
10 years. Judgment is 11. Last part and the
20B2C. And what is the period of detention?
On 16/10/2023, he was 8 years.
Have you handed over a copy to the London State Council?
Yes.
So, Mr. Tripathi, এটা বা 6 বছর লেখা ইউ
Total actual sentence period under as per jail man
8 years 11 months
17
এটা কেবে গেল 16 মানে ଆଉ ମାସେ ତମ 9 ବର୍ଷ
9 ବର୍ଷ ମାସେ 7 ଦିନ
the London Council for the State has London Council for the Appellant, that is first one CRLA 314 of 2020 to 2013. Produce the surrender certificate. Is taken on record. He submits that out 10 years of substantive sentence imposed by the London Trial Court, the petitioner has already undergone more than 9 years of sentence. And since he has not flouted the terms and conditions of the interim law, and even though paper book has been prepared, the case is not likely to be taken up for hearing in the near future. Bail application of the petitioner may be favorably considered, and counsel for the state oppose the prayer for bail. As he has produced the custody certificate, this is taken on them. Considering the submission made by the London Council for the respective parties, sentence imposed by the London Trial Court period already undergone by the petitioner in judicial custody, and conduct of the petitioner in complying with the earlier interim bail order, and keeping in view the ratio laid down by the Honorable Supreme Court in that Muhammad Muslim case, bail is allowed.
Number 7/3/2013, flag B, making high recently flag B, application for the retirement office past looking in there. Flag B.
So which one you want to not face? Okay, this case number 738 of 2013 not face for you. Yes, next. Eight, Mr. Roy.
My lord, may I please lordship?
Yes.
My lord, this petition was in custody since 17/11/14, my lords.
There are two interim applications for bail. One is for appellant number 1, the other is for as such for the all the
My lord,
applications.
one, my lord, I am placing, my lord. Two is absconding after availing the interim bail for 15 days.
No, you want to place which interim application? Whether the
2294, my lord.
or 2294. So this is an ground. What ground you have taken?
My lord, he is more than 8 years, 6 months in custody, my lord. And
What is the
second thing is
sentence?
as the another
Sentence imposed, Mr. Roy? 10 years. 8 years kete kouchandi?
8 years, 6 months.
So what about the custody certificate?
My lord, custody certificate was called for on 25/4. That was reflected in IA number 1103 of 21.
कौन है custody certificate कौन है?
1103 of 21. That is paragraph 2 and paragraph page 2, paragraph 3 and 5.
Why don't you collect? It can be available to you. Why are you always depending on the state council? The convict has a right to get that custodial certificate from the concerned jail superintendent. So you get it. All right. The Learning Council for the this is IA number 2294 of 23 order category. There is an application for bail. Learning Council for the appellant submitted that out of 10 years of sentence imposed by the Learning Trial Court, the appellant number 1 has already undergone sentence of more than 8 years and 6 months. Let the Learning Council for the state produce the certificate. So 18th. He is now in jail in sub-jail Parla Kinadil. No? Okay, next case. You have been earlier released on interim bail. This is IA number 146 of 23. It's a case of how many appellants are there in
Two appellants.
and you have filed bail for 2 appellants. Okay. What is that? Judgment? Agent, agent. এটা কে হেমন্ত দ্বারা দিয়ে appellant number A1 এটা হচ্ছে আপনার ডেট হচ্ছে সার্টিফিকেট ডেট হচ্ছে 22/10/2023 তাদের দেখুଛନ୍ତି টোটাল পিরিয়ড 6 ବର୍ଷ 10 ମାସ 22 ଦିନ তো ଆଉ ମାସେ ଯାଇଛି ହେଲେ 6 ବର୍ଷ 11 ମାସ 22 ଦିନ ଆଉ 8 ଦିନ ହଁ ହେଇଯିବ 7 ବର୍ଷ ହେଇଯିବ ୟାର ହବ appellant number 1 ର 7 years. What about ये जो A सूर्या द्वारा is appellant number 2. 8 years. Okay. 8 years 1 month. Loko budi jano. Luka. Yeah. All right. 20B2C. For the Learning Council for the petitioner and Council for the state. The Learning Council for the petitioner submitted that the appellant number 1, K. Hemanto Dora, is in judicial custody for more than 7 years, and appellant number 2, S. Durjoy Dora. Huh? S. Durjoy Dora is in judicial custody for more than 8 years. And the appeal is not yet ready for hearing, and therefore their application may be favorably considered. He has produced the custody certificate of both the appellant, which has taken on record. And counsel for the state opposed the prayer for bail. Considering the submission made by the land counsel for the respective parties, since out of 10 years of sentence imposed by the land trial court, the appellant number 1 has already undergone 7 years, and appellant number 2 has already undergone 8 years of substantive sentence, and there is no chance of early hearing of the appeal, keeping in view the ratio laid down by the Honorable Supreme Court in Mohammed Muslim case. There is allowed.
Second hearing. Second hearing.
This one has been convicted. One of the things we fix of the post-trial. Yeah.
So you have supplied the deposition copy?
Yes, I've done that.
And Mr. Tripathi, you are supposed to obtain instruction about the criminal antecedent. How many cases are there? No case. So, Mr. Das, what is the date of custody?
I was in jail for 8 months.
It is you are taken into custody on 16/7/2017, released on bail on 27/3/2008. So that may be for 3 and 5 years, 8, maximum 8. So that is during 8 months. Then after the judgment was pronounced on 6/8/2022.
Yeah.
Have you been released ever on interim bail or no? So that is 1 year and let us say 4 months.
That's total about 2 years.
2 years. 2 years old. Okay. And what sentence has been imposed by the London Trial Court?
10 years.
10 years. And who is the victim? Doctor? Doctor, case, no physical injury, no signs, symptoms. Okay, wearing apparels not produced. Certification test was done. Okay. Then number 2. How many days after the occurrence he was examined? Next day. The FIR was lodged on 14/7. 13/7, FIR on 14.
Yes.
And doctor's evidence is that 14/7. Yes, Mr. Tripathi. Minor. Hard Mr. Satyadev Das and senior advocate, Mr. Tripathi. The counsel for the appellant submitted that the petitioner was taken into judicial custody in connection with this case on 16/7/2017, and he was granted bail on 27/3/2018. And after pronouncement of the judgment by the London Trial Court on 6/8/2022, he was again taken into judicial custody, and as such, he has remained in custody for more than 2 years. And counsel submits that the occurrence in question stated to have taken place on 13/7/2017, and the FIR was lodged on 14/7/2017, and on the very day the victim was examined by PW5. And even though it is the prosecution case that the victim was minor, but the doctor didn't notice any physical injury or any sign and symptoms of recent sexual intercourse. It is further argued that there are good chances of success in the appeal balance of convenience is in favor of the appellant, and therefore the bail application may be favorably considered. And counsel for the state opposed the prayer for bail and placed the evidence of PW2 and PW5. Considering the submission made by the learned counsel for the respective parties, nature of evidence produced during trial, sentence imposed by the learned trial court, they are already undergone by the petitioner in judicial custody, absence of any chance of early hearing of the appeal, and absence of any material before this court that while on bail during trial, the petitioner has misutilized his liberty in any manner. I am inclined to release the petitioner on bail, allowed state realization of fine.
I think that
Have you got it, Mr. Tripathi? Well, it's a case of what sort of injury? How many fingers amputated? You are found guilty under section
307 from years. Completely and government. You have
sentence is 10 years.
Yes,
And you are on bail during trial. So since when you are in custody?
2019.
That means 4 years and
6 months or more.
6 months. No CA
No,
or the land counsel for the petitioner land counsel for the state. The land counsel for the state has produced the written instruction received from IIC Bonigocho police station to the effect that the petitioner is having no criminal antecedent. He has also produced the photographs of the affected part of the injured bracket PW1. Considering the submission made by the land counsel for the petitioner that out of 10 years of substantive sentence imposed by the land trial court, the petitioner has already undergone sentence of 4 years and 6 months. And there is no likelihood of the appeal being taken up for hearing in the near future. I am inclined to release the petitioner on bail, stay relation of fine. There is no such idea. Have you verified the order sheet?
Verified from the order sheet uploaded.
The order date 1/7/2023 in which case number 735 of 2013, there has been stay of realization of fine pending disposal of the appeal. This case is disposed of. Yes, next.
May I please your lordship? My lord, 10 years RI, out of 10 years, my lord, has already been suffered in
You have received the case diary? Evidence copy you have received?
Yes, madam.
Okay. And notice sufficient? Quite a case of conviction on it. So let it be on 11th of December 2020. As prayed for by the London Council for the appellant court. Yes, next. Mr. Lenka. Dr. Balas. Yes, next.
Item 17.
Mr. Roy.
May I please, Your Lordship?
Yes.
My lord, this petitioner was convicted for 10 years.
What offense is?
304 part 1, my lord.
Have you supplied deposition copy?
Yes, my lord.
So you are on bail during trial or custody?
No, my lord, custody. Since 28/8/2018, I am in custody more than 5 years. My lord.
5 years, 3 months. 5 years. Sentence imposed is 10 years.
10 years, yes.
What is the operative part of the judgment?
My lord, that is at page 34, last and 35, my lords, of internal page. The last line, I feel the interest of justice will be best served if the convict is sentenced to arrive for 10 years.
Okay. Eyewitnesses are there?
My lord, one eyewitness, my lord, that is PW1.
And who is the doctor?
My lord, doctor is PW
22.
22.
So what is the weapon of offense?
Henga, my lords.
How many blows you have given?
My lord, as per postmortem report, my lord, 2 lacerated injuries and 3 to 4 swelling injuries.
Lacerated on knee, Writing.
That is at page 15.
Okay, so these are all, Mr. These are all on the wrist and knee.
Yes, he is the cousin brother of this petitioner, my lord.
Fractures have been caused, of course. PBF people are okay. So, what is the cause of death? There was compound fracture. Okay, then hemorrhage, shock due to multiple bone fracture. Okay.
There is no premeditation, there is no intention, my lords, only because they are quarreling.
Eyewitness has supported the prosecution case.
Yes, my submission.
PW 1 to 8.
PW 1, 3.
1 to 8, all are
Two is not an eyewitness, 2 is the informant, and after my lord, he is the injured. And when the petitioner beaten her, she fled away from the spot.
So
she is the wife of the deceased.
But 3 to 8 are also the eyewitnesses according to Mr. Tripathi.
Yes, 1, 3, 4, 5, 6, 8.
अब ये के कौन खाली कोई दूर
नहीं 1, 3, 4 1 टा main.
ये नहीं कौन Mr. Lati told that you are smart. What about the criminal antecedent, Mr.
No antecedent.
You have not received it?
No.
Get it here. The Land Council for the state submitted that he has received the deposition copies of witnesses from the Land Council for the appellant. However, he may be given some time to obtain the instruction about the criminal antecedent if any against the appellant. Put up this matter on 18/12/2020. Yes, next.
Item 18.
It's all right. You can file another case. It cannot be once it has been shown, affidavit has been shown. You can file an additional affidavit. What is there? All right. Yes, next case.
Item 19.
What is this matter, Mr. Das?
The application filed on Section 229 same has been rejected by the trial court manner.
Okay.
According to the complaint.
Okay, we'll hear it tomorrow. Today, okay. No, Monday. It will take some time. Monday रे सेमती कही होंगे supplementary list आपन यदि सुनिया को interested होचंदी then it may come in the supplementary but
then let it be Tuesday.
Okay, Tuesday. Mr. With the consent of both the parties, put up this matter on 12th of December 2020. Yes.
Item 20.
yesterday, I submitted worksheet paragraph
of the evidence of PW1. PW1 evidence.
so that was good. After that, the examination is very examination process. Paragraph 44. Page 8.
ठीक है खाली वो पैराग्राफ खाली लगी ठीक है
Kindly come to paragraph 68. Page 40.
68.
Fine. Yes,
Yes, question. 3W1. 68. Page 26. Yes.
has suffered.
68 का गोटिए पैराग्राफ
गोटिए पैराग्राफ सेटा से पेज में has
हाँ
suffered. In the affidavit, as well as in the verification in the election petition, I have mentioned in paragraph 4 that the particulars of such illegalities, irregularities as alleged in paragraph 7A to 7J are based on my personal knowledge and on the basis of documents filed by the respondent before the returning officer and official records and public documents, which I believed the same to be. Whereas, in paragraph 77, while answering to the question put by my lord, kindly come to page 31. I have mentioned in paragraph 7H of election petition that the respondent has not filed his nomination paper prescribed in Form 2B, which according to me is that the respondent has deleted part 2 of the prescribed Form 2B. So far as allegations with respect to part 3 and part 3A, as has been deposed in the deposition and election petition, there is no evidence to that. According to the question kale, se part 3 or part 3A kotha koile. Then my lord, my kindly come to paragraph 98, page 57, relevant paragraph, relevant portion is at page 61.
61.
Right. 98 paragraph.
61. 98.
Right. 98 paragraph.
Page 61. हाँ ठीक है एक्सेट्रा को कोट लाइन
It is a fact that I have not raised any objection
to the nomination paper filed by the respondent on the date of scrutiny before the returning officer, since I had no knowledge at that point of time that the respondent has made any such suppression of facts and wrong affidavit, which I came to know later on. After coming to know of the same, within the prescribed time, I approached this court by filing the election petition to challenge the election of the respondent. On the date of scrutiny of nomination papers of all the candidates, I had not personally attended, but my counsel, Mr. Asim Amitabh Das, and his associate, one Mr. Saroj, represented me before the returning officer. My counsel, Asim Amitabh Das, and his associate, Mr. Saroj, who represented me, might have knowledge what happened during the scrutiny of nomination papers. Thank you. Pause here for a moment. ସେଠି ଦିଟା କଥା ସେ ଆଗରୁ କହିଛନ୍ତି ଏଭିଡେନ୍ସରେ ଯେ ମୁଁ ଯୋଉ ଡାଉନଲୋଡ କଲି ସେଇଥିରୁ ମୁଁ ଜାଣିଲି ସେଗୁଡାକୁ ଏକ୍ଜିକ୍ୟୁଟ କରିନଥିଲି। ଅସୀମ ଅମିତାଭ ଦାସ କିମ୍ବା ସରୋଜ ଯୋଉଦିନ ରହିଲେ ଡେଟ୍ ଅଫ ସ୍କ୍ରୁଟିନିରେ ତାଙ୍କୁ କଣ କହିଲେ ସେ କଥା ବି ସେ ଡିପୋଜ କଲେଣି। In addition to that, neither Mr. Das nor Mr. Saroj has been cited as a witness.
No, if this particular line is taken into account, then he says that I was not aware and I came to know it later on. So the later on may be that after downloading the same.
That was earlier, not later.
Good.
So you download exhibit 1, 2, 3, 4 and 32, 34, 33, 34, 35 that was downloaded earlier.
ये जो डॉक्यूमेंट गुड़ाक तो माने सब्सिक्वेंटली आसी से तांकर एविडेंस नुहे कि डाउनलोड कॉपी करी किनी हम इलेक्शन पिटिशन प्रिपेयर करलु बेली
हां नहीं मु सेटा केवल आपको अटेंशन आनुची द लास्ट सेंटेंस माय काउंसिल मिस्टर असीम अमिताभ दास and his associate Mr. Saroj, who represented me, might have knowledge what happened during the scrutiny of the nomination papers.
No, obviously, so scrutiny pore जेतु से किछि objection देइनी बा करिनाती रिटर्निंग ऑफिसर पाखरे बा अन्य कोनोसी सोर्स रे दैट्स
कौन है सिए जाने
हां
किंतु ताकू विटनेस रे साइड करता
हां
किंबा ताकठो कोन स्क्रूटिनी रे हला ताकठो मु एया सुनिली से कथा भी डिपोजिशन में
I have noted on the date of scrutiny I have not raised any objection. What I say that presupposes that at least Mr. Das and Mr. Saroj they have not intimated anything about about any lacuna in the nomination paper filed by the respondent. That is the reason why maybe that he has not raised any objection. There was no information before him, at least till the date of scrutiny, when two persons were representing him before the returning officer.
That one is both are counsel.
That any so till that date it's okay. That no object, but thereafter he says that for the preparation of the election petition, he got those documents by way of downloading it. Of course, those are not been proved before this court, and that was from that source or after downloading only he came to know that these are the suppression, these are the deletion in the nomination paper. So up
That
to
is one aspect.
yes,
Another aspect is scrutiny ଦିନ କେମିତି ହେଲା କଣ ହେଲା ଏଇ ଯୋଉ ତାଙ୍କର ଦି ଜଣ advocate ଥିଲେ
ସ୍କୁଟିନି ଦିନ ଏଥିରୁ ଜଣା ପଡୁଛି ସ୍କୁଟିନି ଦିନ ହିଁ ତାଙ୍କ ପାଖରେ କିଛି ତାଙ୍କୁ ମାନେ ତାଙ୍କ ଆଡଭୋକେଟ ବି ତାଙ୍କୁ କିଛି ଜଣେଇ ନା
ସେଇ ଗୋଟା
ହଁ they are noted down.
କିମ୍ବା ରିଟର୍ଣ୍ଣିଂ ଅଫିସର ହାଇ ହ୍ୟାଣ୍ଡେଡଲି କଲେ କି ପରଫେକ୍ଟଲି ଆକର୍ଡିଂ ଟୁ ଲ କଲେ ସେ ବିଷୟରେ ବି ତାଙ୍କର କିଛି ଇନଫର୍ମେସନ ସେ ତାଙ୍କ ଆଡଭୋକେଟଙ୍କଠୁ ପାଇଲା and nor his both of his advocates have been cited as well. My lord, may kindly come to paragraph 101, page 69.
69.
Paragraph 70.
Which page?
Stop.
Softly, the page. Page 70, paragraph, top paragraph. Okay.
I cannot say whether I have filed the downloaded copy of the nomination papers and affidavit filed by the respondent from the official website of Chief Electoral Officer, Orissa, along with the election petition, or even till today. My advocate can say about this. ଯୋଉଟାକୁ ଡାଉନଲୋଡ କଲେ ବୋଲିକି କହୁଛନ୍ତି ସେଇଟାକୁ ବି ସେ ଏକ୍ଜିକ୍ୟୁଟ କରିନାହାନ୍ତି.
That is a fact. In fact, it has not been executed, not filed.
Then, my lord, kindly come to paragraph 106.
Page
79.
79. Page 79.
Relevant portion is that. Yes.
Paragraph 106 no?
Aye.
Question number 11.
Top.
79 KT. Top paragraph.
Then it is a fact.
Yes.
It is a fact that from the date of downloading as mentioned in Exhibit 1, 2, 3, 4, Exhibit 32, Exhibit 33, Exhibit 34, Exhibit 35, and Exhibit W. Exhibit W টা হচ্ছে IA number 20. 24 of 20. It is apparent that these documents were not available when the election petition was filed on 3/7/2009.
Because of the dates which have been downloaded dates. Right.
Then next subparagraph. The downloaded copies similar to Exhibit 1, Exhibit 2, Exhibit 3, and Exhibit 4, Exhibit 32, Exhibit 33, Exhibit 34, and Exhibit 35, and Exhibit W were available with me at the time of preparation of election petition, and those are also available with me now, and my legal advisor can say as to why they did not file those.
Okay.
This is a material.
No, your submission is like this, that it was not within his personal knowledge. He got the knowledge on the basis of these documentary evidence, according to him, which were downloaded prior to the filing of the election petition. So it was his duty to file those documents to verify whether the averments taken in the election petition is correct or not. That is your submission.
Yes.
Yes.
ଆଉ ଟିକେ ନୋଟ୍ କରନ୍ତୁ କି ଫର୍ଦର ସେଟା ମୋ ପାଖରେ ପ୍ରିପାରେସନ ବେଳେ ଥିଲା ଆଜି ବି ଅଛି obviously my lawyers know but I do not know why they did not choose to file.
Mr. One thing, let us say that in view of section 114 of the Evidence Act, if the documents are available with you and you withheld the same, then the adverse inference would be drawn that had the documents been produced, it would have gone against you, that is why. But when those documents have been proved afterwards, exhibited, so in what way it can be said that it has affected you, or it has affected the course of justice, or they have suppressed the truth? 114 जदि से total evidence, total documentary evidence court to no asidanda, matter would have been different. But yes, the document on the basis of which they prepared it, those were not produced before the court. That means the initial document. But those very documents came to the court at a later stage, not only the original but also the downloaded copies. So how can it be said that in what way it has affected the case of the election petition?
Your lordship has put a very vital question. And your allegation that has come, it is not filled up. It are visited, it are not filled up, partly not filled up. Part 3A, 2 to 9 is a totally black, left black. সেই ডকুমেন্টটা ন আসলে কেমন জনা পড়িব যে এই ডিফেক্ট গুলা আছে
ନା ନା ସେ ଡକୁମେଣ୍ଟ କଣ ଆସିଥିଲେ ଆପଣ ଭାବୁଛନ୍ତି ଆଉ ଗୋଟେ ଅଲଗା ଟାଇପ ର ଆସିଥାନ୍ତା ଡକୁମେଣ୍ଟ?
କଣ ଆସିଥାନ୍ତା
ଆପଣ ଯୋଉ ସୋର୍ସ ରୁ ଡକୁମେଣ୍ଟ ଆସିଲା, let us say now the original document has come to the court, downloaded copies have come to you. Is there any discrepancy in the original vis-a-vis the downloaded copies? So if it is not there, then whatever downloaded copies they have collected prior to the preparation of the election petition, how can you expect that there would be something different? So those things would have been there in case the total document suppose totally produced in Athanda court, but it has come at a later stage. You are right that they should have produced, and it was also their duty because they have no personal knowledge. They got the knowledge on the basis of the documentary evidence, and that should have been would have supported their other case. But all the same, those documents have come and on record. Yes.
ଯେ ଯଦି ସିଏ ସେଟା ନିଜେ ପ୍ରଡ୍ୟୁସ କରିଥାନ୍ତେ ତାହେଲେ ଆଟଲିଷ୍ଟ he would not have made a false allegation but he is totally wrong.
No, now also the court can see. Court ଦେଖୁଛନ୍ତି
No, no. Court ଆସିକିରି ଗୋଟେ finding court କରିପାରିବେ. The allegations are not correct.
Court prima facie ଦେଖୁଛନ୍ତି ଯେ total fill
What
up.
is going to submit that he has stated a downright false statement on oath before the court.
माने total part 3 एटा जो fill up ହେଇନି ବୋଲି କହୁଛନ୍ତି. That may not be is so again suppose let us say he has not stated if correctly relating to the a part of the case. So again question comes that whether false, let us say that it is falsehood. Also a part, a one line or two lines of his evidence is not based on record, or it is go to the extent that it is falsely mentioned. So on
if
that
a single material fact is not stated or stated falsely, the election petition is liable to be.
Okay, that you have to satisfy. Because
there are decisions to that.
Okay.
If actually note କରିଥିଲେ ମୁଁ ସେଇ decision
because
if a single material fact is either left to be stated or falsely stated, then the election petition is liable to be dismissed in the
because their case is also that you have your election petition, the respondent has adopted certain falsehood that mentioning the wrong case, wrong things. So they are also to satisfy whether that suppose 13 cases are there. And
that is with respect to criminal.
I'm just giving an example. 10 cases correct information there. 13 cases have been mentioned. 10 cases offense is right, everything. But the rest 3 cases, the offenses, 1 or 2 offenses are here and there.
Yes.
The GR case number may be here and the court may. So again, whether for that reason, the entire thing, that is to be.
No,
all right. I'm noting this point, and you are to support it by the decision that a single
material fact not pleaded
or falsely pleaded can be a ground to dismiss
dismiss the election.
This is obviously that 3A of that not filled up. Partly. Right. Not filled up totally. Okay. It's a false statement. All right. Yes.
Kindly come to paragraph 107. Relevant portion is at 82 and 80.
Para 107. Page wala kete?
82.
Starting relevant portion
ठीक है, move 82 like this. ठीक है.
To the
top.
Which paragraph tell me? 1, 2.
It is a fact.
आपण मु जो कहि नथली जो नोट जो दबा माने गोटे सेही टाइप रो पिन पॉइंट कर देबे माने पेज 82 8 पैराग्राफ हां बस
एते लाइन फ्रॉम टॉप
हां
एते लाइन फ्रॉम
something like that would be pin point yes
it is a fact
hmm.
you lordship
yes
that 4 categories of candidates can contest general assembly election. That is 1. Candidates set up by recognized national political party. 2. Candidates set up by recognized state political party. 3. Candidates set up by registered unrecognized political party. And 4. Independent candidates. It is a fact that candidates set up by recognized national political party and candidates set up by recognized state political party for the concerned state are required to be proposed by one elector of the same constituency as his or her proposal. This also your lordship will get in part 1 of the nomination. Form 2B. I do not know whether the candidates set up by registered unrecognized political party and independent candidates are required to be proposed by 10 electors of the same constituency as their proposal. Why he is avoiding to answer? He is a regular contestant, active in politics in more than 30 years. Why he is avoiding this question? This is he is particularly avoiding consciously because it is neither relevant to the respondent nor applicable. It is applicable for registered, unrecognized political party or independent candidates.
No, they have not pleaded that it was required that there should be 10 proposers. That is not also not there, and you have given only one proposer. So, in that way, how you say so? No, it is nobody's case that for Mohammad Mukim, 10 proposers,
for the purpose,
10 proposers are required.
Respondent being a candidate set up by a recognized national political party. He is required.
Proposer is one. Yes.
And he is required to fill up part 1, not part 2. I am concentrating on part 2. Okay. And part 2 is not relevant. He must say these two things. এইটা আমি মানি চল সেইটাই নোট করছি এটা দিকে নোট করছিলে
Okay, you mean to say that he's deliberately telling this because the part 2 relates to that unrecognized political
party and independent political party and is not relevant for respondent.
Yes.
It is a fact that I have stated in election petition in paragraph 7A that the respondent Mohammad Mukim filed his nomination as Indian National Congress INC candidate for 90 Varavati Kotak Assembly constituency. It is a fact that Indian National Congress INC is a recognized national political party and the respondent is required to be proposed by one elector of the same constituency. I do not know whether a single proposer can be there for all the 4 sets of nomination papers of a
particular candidate.
Particular candidate of a recognized national political party in the election order. Then your lordship may kindly come to next paragraph. 108.
No, even if a candidate can file 4 sets of nomination paper, that is the maximum set of nomination. It may be for a you may be a recognized national political party or state or independent candidate or whatever. So maximum is 4. But so far as that proposer is your question, the last question pacharle. One proposer, can it be for that just for he can no, he can be he can sign in all the 4 sets of one person.
Yes.
Okay.
That is no provision under the act. Okay. किंतु गोटे प्रपोजल करिवो 4टी सेट देई परिवो से केवल 4टी सेट से देई परिवो और रिटर्निंग ऑप्शन देई परिवो
नो जदी मोर कहर था ताले 4टा सेट जण लोक काहे की फाइल करिवो
नहीं तार ऑप्शन अछि से 4 जण डिफरेंट प्रपोजल देई परिवो एवं प्राय दियंती दैट इज द ऑर्डिनरी
मु से आपण जो प्रश्नटा पचारली आपण कहले ना गोटे प्रपोजल 4टा जगह रही परिवो तो जदी गोटे प्रपोजल रो रिजेक्ट हल तो 4टा को रिजेक्ट होची so that is why he can
the grounds of rejection may be different
हां
नो चाटे गोटे
ना ग्राउंड ऑफ रिजेक्शन जदी अन्य गुडा को सब एका थिबो
ताले
रिजेक्ट ही जो तेणु प्रपोजल ऊपर बट whether
stress
no there is some qualification is also required for a proposal. That means suppose Kotak constituency 90 Barawati constituency one man of Ongul who is a permanent resident of Ongul, can he be a proposer of that 90 Barawati constituency? He must be a member. ନାଇଁ ମୁଁ କହୁଛି ଭୋଟର ଲିଷ୍ଟରେ ଯଦି ନଥିବ ହେଇପାରିବନି ସୋ ସେଥିପାଇଁ ସପୋଜ ବା ସେଥିପାଇଁ ପ୍ରପୋଜର ମଧ୍ୟ ଗୋଟେ କିଛି କ୍ରାଇଟେରିଆ ରହିଛି ତେଣୁ ଜଣକୁ ଯଦି ସେ 4ଟା ଜାଗାରେ ଜଣେ ବା ପାର୍ଟି କରିଦେଲେ ତାହେଲେ if one is found to be then obviously ସେମିତି ମଧ୍ୟ ଆପଣ 10 proposal required for the independent candidate say 10 जन को जदी देइथिबे 10 जन को मानकर गोटे प्रपोजल देखा गला जी ये से constituency रो न ता ना voter list रे नाही गला सब तो जीवन so obviously so that is why it is all right you can all right
kindly come to paragraph 108 at page 80 I cannot say whether Form 7A, which deals with contesting candidates, is to be maintained by the returning officer, wherein the name of the candidate, address of the candidate, party affiliation, and symbol allotted is maintained by the returning officer. I am not able to say whether this particular Form 7A which is shown to me and marked as X by 8 in court today has been prepared by the returning officer in connection with the election in question or not. I cannot say whether there is any statutory provision to maintain notice of nomination in Form 3A to be maintained by the returning officer. which is shown to me in court today and marked as X/9, where apart from serial number of the nomination paper, name of the candidate, name of the father, mother, husband, age of the candidate, address, party affiliation, particulars of the caste, tribe, etc., electoral roll number of the candidate, name of the proposers, and the electoral roll number of the proposers are required to be maintained. It is a fact that after scrutiny of nomination, a list of validly nominated candidates in Form 4 is maintained by the returning officer, where the name of the candidate, name of the father, mother, husband, address of the candidate, and party affiliation are mentioned. This is the Form 4 of election in question, marked as Exhibit A. Why I place this paragraph before your lordship? My object is twofold. One, I want to submit before your lordship that the statement made by the returning officer PW3 that I have meticulously followed all the requirements of law as enjoined under the Constitution, Representation of People's Act Part 2, as well as Handbook of Returning Officer Exhibit A. This is one aspect. Second aspect, whether a material question is being asked to a candidate who has been consistently in the election play for more than 30 years, deliberately avoids funds to Muhrajan. Next paragraph to the I cannot say whether in the election in question total number of 11 candidates filed 27 number of nomination papers in total, and that the same are mentioned in Form 3A, Exhibit A. From 3A, that is top. In Exhibit A, 3 names of candidates find place under the category 1, under the heading of national and state level recognized political party. 3 जनकर ना माने रेस्पोंडेंट सम्मिलित इलेक्शन पिक्चर 2 जन नेशनल पार्टी जन स्टेट recognized political party. Under category 2, under the heading of registered political party other than national and state level recognized political party, the names of candidates find place, 5 candidates find place, and under category 3, under the heading other candidates, 2 names find place as independent candidates. I cannot say whether the name of one candidate who comes under category 2 and whose name is there in Form 3A has not been mentioned in Exhibit AA, that is Form 4, as his nomination was rejected by the returning officer. Looking at the document marked Exhibit X9, I cannot say whether the candidates set up by registered unrecognized political party and independent candidates are required to be proposed by 10 electors of the same constituency as their proposals, and the same has been done in the election in question. Then, your lordship may kindly come to paragraph 109, next paragraph. I cannot say 85 to 87. I cannot say whether the name of one independent candidate, namely SHRI Pandey, which is there in Form 4 filed Exhibit A, list of validly nominated candidates is not there in Form 7A marked Exhibit X by 8 as because he withdrew his candidacy.
Just page पे जाओ, next page.
It's a fact.
You are pressing?
I am pressing paragraph 109.
Yes.
Available to your lordship at page 85 to 87.
Okay.
I cannot say whether the name of one independent candidate, namely SHRI Pandey, which is there in Form 4 by Exhibit AA, is not there in Form 7 marked as X by 8 at 7A and marked as Exhibit X by 8 as because he withdrew his candidature. Form 4 टा हला validly nominated candidates. List of validly nominated candidates. Form 7 टा हबो after withdrawal list of contesting candidates. It is a fact that in paragraph 2 of my election petition, though I have mentioned the name of political party with their respective election symbol along with the name of contesting candidates, but I have not mentioned as to whether the particular political party is a recognized national or state level political party or a registered unrecognized political party. जो गोटाक से फॉर्म 7A रे कहवा कथा एई से कहवा कथा से कहूना. It is not necessary on my part to indicate in my election petition as mentioned in the proviso, first proviso to subsection 1 of section 33 of the Representation of People Act 1951 that candidates not set up by a recognized political party shall not be deemed to be duly nominated for election from a constituency unless the nomination paper is subscribed by 10 proposers being electors of the constituency. Since in this paragraph 1, I have focused my amendments to the candidature of respondent. It is not a fact that whatever I have mentioned in paragraph 7A of my election petition, that in the notice under section 31, a nomination paper completed in the prescribed form is to be delivered is not correct, and a candidate can file maximum 4 nomination papers as per section 33(6) of the RP Act 1951, and that I have willfully suppressed this sentence. I cannot say whether in my election petition I have filed the format of Form 2B appended to the Conduct of Election Rules 1961. I cannot say whether I have not mentioned in details regarding the prescribed Form 2B in my election petition. I am not able to say whether I have filed the Form 2B of the respondent, which according to me was not in the prescribed Form 2B, along with the election petition. I will also not able to say whether I have reflected in verbatim as to what mentioned by the respondent in Form 2B in the body of my election petition. These amendments, according to me, are material. If they allege that the form to be filed by the respondent is not in the prescribed form, they have to annex a copy of the nomination paper filed by the respondent in Form 2B along with the election petition, which he said I have downloaded and it is under my possession. Why it is compulsory?
Yes, which provision of CPC was
Right. Reliance should claim on Order 7.
media CPC. Yes. Rule
Rule 14.
Order 7, Rule 14 CPC.
Again, kindly to look to the headline.
Just a minute. Order 7. Rule
Order 7, headline and together.
Rule 14. Yes, production documents relied on.
Okay. Order 7, the headline and
What?
beginning.
Beginning.
Plain.
Plain, right.
ସେ କଣ କଣ ଦବ ସେଠି A to I ପର୍ଯ୍ୟନ୍ତ କହିବ. These are requirements. Then kindly come to 14.
14.
Production of document on which the plaintiff sued or relies.
Just a minute.
ଆଗେ ସେ କହିବେ କଣ କଣ ତାଙ୍କର ଇଏ specific allegation. No doubt, the plaintiff, the election petitioner, in his own election petition says, refers to the Form 2B filed by the respondent.
Right.
Therefore, he sues upon that document. And the document upon which he sues, according to his own statement, he downloaded it from the web portal and was in his custody and possession. There is no dispute about that.
Yes.
Now come to, let us see language employed in Rule 14. Production of document on which the plaintiff sues or relies. He sues upon and relies upon the nomination form to be filed by the respondent. Now, where a plaintiff sues upon a document or relies upon a document in his possession or power, all these conditions, preconditions are satisfied with this section. In support of his claim, he shall enter such document in a disk. This is material. And shall produce it in court when the plaintiff is presented by him, and shall at the same time deliver the document and a copy thereof be filed with the plaintiff. If your lordship refers to the election petition and copy supplied to me, this requirement is not complied. Horn 2B, upon which he sues upon and reliance, has neither been filed along with his election petition, not have been supplied to.
No, there must be a column in that election petition about the documents relied upon what he has stated.
Nothing.
Just let us come to that.
Definitely.
Election petition. ସେଟା ପ୍ରାୟ ଶେଷରେ ଥାଏ ତ
ଶେଷରେ ଥାଏ
କୋଉ ପାରାଗ୍ରାଫ
page 21
ହଁ ମୁଁ ସେଇଠି ତ ସେଠି ଲେଖିଛନ୍ତି documents relied upon ରେ nomination papers
along with affidavit and other documents filed by the respondent before the returning officer on SHRI to be called for from the custody of returning officer. Downloaded copy of the nomination paper and the affidavit filed by the respondent from the official website. एटा से डाउनलोड करछंती ताको पोजीशन रे अछि किंतु से सेटाको लिस्ट रे देले किंतु फाइल करे
तो no so dita jinse ei jo section ta apno place kale rule 14 रे से जेतु सेटा को रिलाय अपन करिचंती आ सेटा पोजीशन रे अछि बेली से कहउचंती तेनु तांकर प्रथम रिक्वायरमेंट थिला जे ही शैल एंटर सच डॉक्यूमेंट इन ए लिस्ट व्हिच ही हैज गिवन and shall produce it in court when the plaint is presented by him and shall at the same time deliver the document and copy thereof to be filed with the plaint.
For supply to the
other side, okay, respondent, opposite party, yeah, you. You know, second requirement is अच्छा.
Consequence का कौन? So that subsection 2 question, where any such document is not in the possession or power of the plaintiff, he shall, however possible, wherever possible, state in whose possession is power.
It applicable.
Applicable. It applicable. Document which ought to be produced in court by the plaintiff when the plaint is presented, or ought to be entered in the list to be added or annexed to the plaint, but is not produced or entered accordingly. If he enter kale, kintu produce kale, shall not without the leave of the court be received in evidence on his behalf at the hearing of the suit. And nothing in this rule shall apply to document produced for the cross-examination. Eta applicable.
So 3 is relevant.
1 and 3.
1 and 3. Okay. So here.
Yeah,
no leave petition has been filed accordingly.
किंबा जदि से एनेक्स न करिवे से जदि इन वर्बाटिम डिस्क्राइब करिवे ताको पिटिशन रे रेस्पोंडेंट जो फॉर्म टू बी करछथि सेटा भी चलिबो सेटा भी से करना से लिस्ट एंटर कले फाइल कले नि कि प्लेन सागर दिया दिबा पे फाइल कले नि क्या किंबा वर्बाटिम रिप्रोडक्शन
Now, Mr. Mishra, another thing is, let us go a step further. If it is your case that they have simply entered these documents in the
At the end of the
documents relied upon, they have not filed those documents as they were required to do as per section 14(1), and in case they have not done so, they should have sought for leave of the court to be received in evidence. Suppose that petition has not been also filed, but they tendered the documentary evidence. Okay, in that respect.
That should not have been allowed. My submission is,
No.
and if allowed, ये जोटा डाउनलोड करथिले सेटा मूल देई ना आ जदी भी दबा को चाहिदांते आपन को परमिशन नहीं देथान सेटा भी लीव मागिना आ प्लेन रे दबा पे भी कॉपी अदर साइड की सर्विस सब में भी देना so three lapses consequence of he cannot lead evidence
they माने डाउनलोडेड कॉपी जोड़ाक तांको पोजीशन रे थिला सेगुड़ाक जदी से एविडेंस से ताको आनी थांते हला
आपन को परमिशन नहीं
हम परमिशन नहीं हां हम कोर्ट रो परमिशन नहीं कि नहीं ताको आनी थांते जेतु से टोटल
सते बेला आपन कोइ थांते आगे कॉपी ना को दियो
हां जदी से टोटली आनी नहांती ताले हाउ दिस 14(3) has been flouted
ना से जदी न आने जे consequence ता कोन
हां
आपन पचारछन consequence कोन
हां
जदी
सेटा पर कहले जे shall not without the leave of the court be received in evidence तेणु से जिंस को तो आनी नाती रिसीव तो हम करिनी
नहीं तार पुनी consequence कोन हबो
रिसीव तो करनी और consequence
जदी न हेला भी हां ताले consequence कोन हबो ना ए संपर्क में ताकर जो pleading अछि that will not be available to be marshal and if marshal shall be ignored by the
that means what you want to say that downloaded से जो डाउनलोडेड कॉपीज रु तांकर जो अवरमेंट्स नहीं चंदी जे डाउनलोडेड कॉपीज रु हमें एटा जानिलु सेटा जानिलु ये संक्रांतीय सब एविडेंस एटा को कोर्ट शुड इग्नोर इट दैट इज योर सबमिशन So this requires a citation. So citation must be a case where simply it has been entered into the list, it was not filed, not leave was granted, but evidence was adduced on basing on that document, which was not produced in court. So what would be its effect? Okay, yes.
Then kindly come to the next question sample. it is a fact
Yes.
that in page 8, last sentence, under paragraph 7b, though it relates to paragraph 7b,
You are placing page 87 now?
yes, sir.
87 who sub-paragraph? Second sub-paragraph.
Right.
Okay.
It is a fact.
Ah.
It is a fact that in page 8, last sentence, under paragraph 7b, I have mentioned that the respondent has submitted 4 sets of nomination papers with affidavit. It is also a fact that in page 7, 6th line from the top, I have mentioned that respondent filed his nomination paper before the returning officer on 2/4/2019, but the same is not in the prescribed form. And तारी ऊपर एक क्वेश्चन कराए ये जो पैराग्राफ की मैं आपन का आगे प्लेस कर दी तो देयर इज ए अनोमली गोटा जगह रे थर्ड लाइन रे अछि पेपर्स फोर्थ सेट ऑफ नॉमिनेशन पेपर्स फिफ्थ लाइन रे अछि नॉमिनेशन पेपर तने ये जो चारि सेट नॉमिनेशन तंगरा अभियोग को जदी लिटरली पढ़ा जाए ताको अभियोगरु या अर्थ बाहरिबो से जो 4 सेट नॉमिनेशन दाखल करछथि सेतु गोटिए सेट नॉमिनेशन पेपर इज नॉट इन प्रेस्क्राइब्ड फॉर इंक्लूड यही अर्थ यदि लीड करूची ताले आई विल गो फर्दर काहे टिके आपको आउटर देखंतु.
It is a fact that in page 8, last sentence under paragraph 7b, I have mentioned that the respondent has submitted 4 sets of nomination papers with affidavit. It is also a fact that in page 7,
69
from the top, I have mentioned the respondent filed his nomination paper before the response returning officer on
paper. Before returning officer on Wednesday, but the same is not prescribed.
Second sentence to paragraph 7a.
So
ये
question
दीटा जाक सेंटेंस को जदि हमें मिसई करी पढिबा ताले अर्थ हो 400 नॉमिनेशन दाखल करिबाटा थय सेतिरु गोटिए नॉमिनेशन का नॉट इन प्रेस्क्राइब्ड फॉर्म ए कथाटा टिके नोट करो.
what is the question put by the court or it was
Yes.
from these two?
Eta am
Acha apango question.
whether from these two sentences it can be inferred that the other 3 sets of nomination papers filed the respondent were in prescribed form to be, and that the affirmations taken in the election petition are not correct. So, should have clarified that because se कहते it is not correct.
Okay, so let us say somebody is filing 4 sets of nomination paper, and in one set there is some defect. In the other 3, there is absolutely okay. So it can be accepted. There is no problem. Merely because one line. So there is no dispute about that.
That is the importance of this. Reference may be made to section 36(3), subsection 3. Nothing contained in clause B or clause C of subsection 2 shall be deemed to authorize the rejection of the nomination of any candidate on the ground of any irregularity in respect of a nomination paper if the candidate has been duly nominated by means of other nomination paper, another nomination paper in respect of which no irregularity has been committed.
So we will continue tomorrow. Yes. By the way, Mr. Misra, how many dates you are expecting to finish? Because I have to also accordingly plan it out, because I am taking note of it and then mentioning all those things. So after you finish, then they will also, then your written note of submission will be given.
Both parties
Right.
will be given sometime at least
So
10 to 15 days.
how many dates you are expecting? Because you are now on that form to be.
Form to be 7A.
7A. The other parts are about.
7A form B.
It covers almost 13 issues of that. 12 issues.
Total 30.
30.
12टा इश्यू से कवर करूची मु केवल 7A ऊपर बोधे 20 जाए चल तो अच्छी अभी एविडेंस अच्छी प्लेस करी मैं तो अच्छी provision of law.
No, what I was expecting to you are to wrap up your case argument by end of this month, so that I'll give them opportunity in January.
7A.
For 7A, I thought that the entire argument.
Sorry, but and they will have take extensive time, and they are the petitioner. Right?
Obviously, that's they must be taking note of it. Your submission, they are taking note. They have to reply.
Right.
So whole thing is that I must be at least. I also require at least 2 weeks time to prepare the judgment.
To prepare the judgment, your lordship require. If not,